Thank you, sir.
Okay.
The dumpster.
Good afternoon. I'll call this meeting of the Job Growth, Energy, Affordability, Policy, and Finance Committee to order. Today is Monday, April 18th. First order of business is approval of the minutes.
You nailed it.
Representative Wagenius moves approval of the minutes dated Wednesday,
You
April
think, huh?
13th. What's that?
You think so, huh?
And let the games begin.
Representative Wagenius, do you wish to move the minutes, approval of the minutes from April 13th?
I will do that.
Representative Wagenius makes that motion. Is there any corrections or additions to the minutes? Seeing none, all those in favor, please signify by saying aye. Aye. Opposed, say nay. Motion prevails. The minutes are adopted. Members, good afternoon. Let me first of all walk through our tentative schedule for the day, kind of the outline that's going to be before us. We're going to be beginning with a conversation about the A17 amendment. This is not a hearing on, we're not going to be voting on that amendment. We're not going to be taking action on it. I think that this is an important item that merits the conversation and discussion, so members of the committee are aware of it. So what we're going to do is we're going to have a conversation about that amendment. Members will ask questions, we'll have public testimony. Then what we're going to do is we're going to move the delete all amendment to get that bill in front of the committee so that it matches up with our research summary. And then at that point, we'll have nonpartisan research cover the bill, do a walkthrough of the spreadsheet as well as the policy language. At the completion of the walkthrough, and we'll take member questions from nonpartisan staff. Next, we'll go to public testimony and allow individuals of the public to come up and testify. We have floor session at 4 o'clock, so I'm anticipating that we will still be taking public testimony when the floor session begins. So I would imagine, my expectation will be probably about 3:15 or 3:30. We will recess the committee to the call of the chair to provide the opportunity for members to caucus, get ready for the floor session. Upon the completion of the floor session, rather than reconvening the committee, the GOP and DFL committees, my understanding is the DFL is going to be caucusing and the GOP will caucus. I would suggest you get some food because we're going to be getting food on the GOP side. And then we'll come back and we'll continue with public testimony. Upon the completion of public testimony, either we will adjourn for the evening and come back tomorrow for amendments and action on the bill, or if the public testimony is completed, we'll begin markup and take action on the bill this evening. It's really going to depend upon the amount of public testimony, the amount of dialogue from members of the committee. But we have this room all day today, and so either we'll be taking action on this bill today or we'll be taking action on it tomorrow. It's going to depend upon those variables. So that's sort of the outline that I see with the schedule. Again, we'll be recessed when we go to the House floor for caucus and for floor session, grab food, committee caucus, and then come back. So at this point, we'll run to questions from members of the committee. Representative Isaacson.
Just, and maybe there was an email that said this. We anticipate tomorrow meeting at what time? I just don't.
Representative Isaacson is going to depend upon how much we get done tonight, because there's a possibility that we may not complete public testimony tonight, so we would maybe come in earlier. So just, keep your eyes and ears open. We'll make an announcement tonight or hopefully this afternoon, but we want to make sure we just have flexibility.
Thank you, sir.
Representative Clark.
So, Chairman, just to be clear, so I have a couple of witnesses I wanted to testify possibly on amendment, but you would rather have them testify during the public testimony period, is that right? I just want to make clear.
Sure. No, Representative Clark, what we'll be doing is we'll be taking public testimony on the bill, and then upon completion of whenever public testimony is over, when we begin the markup process, that's when we'll have testimony on the individual amendments.
Oh, you will? You will have that?
Yep.
Oh, okay, thank you.
Okay. It's just that I can't tell you when that's going to be because, as I look out here, there may be 2 people who are going to testify, and we'll go right to amendments. I could be wrong about that as well. So, so that's where we're at. Any other questions for members of the committee? Okay. So with that, first of all, we're going to have a conversation. Is Ms. Koch here? You can come on down. And members, in your packets is the not there. Thank you. All right, in your packets is the A17 amendment. Now, I'm not going to formally move that amendment before the committee again. This is just for a conversation, and I wanted to make sure members are aware of this issue. So Again, this is going to be sort of an informational aspect of it. Welcome to the committee. Please state your name for the record and proceed with your testimony.
Very good. Thank you, Chair Garofalo, members of the committee. I am Mary Margaret Zindran, Executive Vice President of the Minnesota chapter of the American Institute of Architects. We are speaking today in support of the amendment before you and are joined in this support by ACEC Minnesota, the American Council of Engineering Companies. At the center of this amendment is a federal tax deduction, 179D. 179D enables a private sector building owner to deduct the cost of energy saving systems up to $1.80 per square foot. 179D also encourages energy efficient design in publicly owned buildings. Since public entities are not taxed and therefore not eligible for a tax deduction, this incentive is designed to encourage architects, engineers, contractors, environmental consultants, and similar entities to create energy-efficient buildings for the public. In order for the tax deduction to be realized, public building owners provide a letter or form with specific information required by the IRS. 179D is good policy. It generates energy-related cost savings for business and government, reduces carbon emissions, shrinks the amount of wasted energy buildings produce, and grows private sector jobs, both new hires and retained workers. It is the best kind of innovation incentives, as it employs a technology-neutral approach focused on outcomes rather than methods. But without clarifying action, what Congress intended with 179D and its recent extension is unlikely to be fully realized in Minnesota. A handful of public entities in Minnesota are pushing architects and other designers to, in one way or another, share the tax deduction with the governmental entity. This issue is at the core of the amendment before you today. The question is, should Minnesota's public entities be allowed to redirect the value of this federal tax deduction, to shift it from the intended recipients, tax-paying entities like architects and other designers, to the public entities benefiting from the energy-efficient design? For many reasons, the answer to this question should be no. This was tried by federal agencies and discontinued. Back in 2012, a federal investigation was launched into the General Services Administration, which was trying to garner reduced costs and generate revenue by asking designers to redirect 19% of what they were entitled to receive under 179D directly to the GSA. Following congressional scrutiny, the GSA discontinued this practice. The state of Massachusetts also corrected this type of activity through an official notice posted in 2011 that remains in effect today from the Massachusetts Division of Capital Asset Management and Maintenance, or DCAM, a helpful precedent for the amendment before this committee. The Massachusetts notice states that, contrary to previous statements made by its personnel, DCAM will not seek any compensation, fees, sharing, deduction from design fee, or otherwise in exchange for conferring this benefit upon the designer. While it can be asserted that the word may in 179D related to public entities opens the door to such compensation or quid pro quo, both the federal and Massachusetts examples show that there is a strong case to be made otherwise. Most governmental entities do not try to redirect the 179D tax deduction to themselves. There are two key reasons for this. One, it supports job growth and the environment. Local governments throughout Minnesota and state governments and public institutions throughout the nation routinely sign the 179D allocation forms and support the broader private sector job creation and environmental benefit this tax deduction incentivizes. And two, legal concerns. Tax analysts note concerns about potential violation of anti-augmentation laws that would require separate approval of revenue creation methods, risks that the firm or the public entity could be sued for antitrust or anti-competition, and risk that a shared 179D tax deduction may be disallowed in an audit. On the flip side, There is negligible liability risk in public entities signing allocation forms. IRS lawyers made clear in a 2011 communication to Congress that the liability risk involved is very limited in nature. The IRS guidelines simply ask for verification that this designer worked on this project and the amount a third-party reviewer has determined that the designer is eligible to deduct. The specific language requiring the signatory to attest that the information provided is true to the best of their knowledge is no higher standard than a witness on the stand in a court of law, something people swear to every day. It is not a reasonable excuse for not signing the allocation form. Our state is a leader in energy-efficient building design. For Minnesota architects to receive this deduction for public design work done across the country, but not for work done for the state of Minnesota, the University of Minnesota, or MnSCU, just doesn't make sense. Architects believe in and very much support the work of the state of Minnesota and our public institutions. The dollars gained through this deduction are dollars designers put toward hiring in the boom times and avoiding layoffs in the lean times, actions which contribute positively to Minnesota's economy. By supporting this amendment, you will bring needed clarity, solidifying the legislative intent of your colleagues at the federal level. The intent to grow a nationwide base of energy-efficient buildings and expertise in energy-efficient building design that serves our nation's interests. Chair Garofalo, members of the committee, thank you for your time and attention. I will do my best to answer any questions you may have.
Thank you very much. Is there any questions for the testifier? Representative Hortman.
Thank you, Mr. Chair. If the testifier could just repeat her name and affiliation.
It's an unusual last name, so I don't blame you. Mary Margaret is my first name. Last name is Zindran. And I'm the Executive Vice President of AIA Minnesota, the American Institute of Architects.
Thank you.
Any other questions from members of the committee? And you'll be sticking around because I think we're going to get some counterbalancing testimony,
Sure.
and maybe we'll have a little debate up here with you too. So thank you very much. Mr. Swanson, the Office of Vice President of University Services, are you here? Welcome to the committee. Please state your name for the record and proceed with your testimony.
Mr. Chairman and members, my name is Brian Swanson. I'm on the finance staff at the University of Minnesota, and I'm the lead on the 179D issue for the U. I'm speaking today about our concerns with the proposed legislation and are speaking in opposition. I had intended to go over the basics of 179, but the AIA, I think, did an adequate job of describing what exactly the legislation is, so I'll skip to the part where we disagree. The proposed amendment today would require all public entities to give away the value of the deduction without obtaining any corresponding public benefit. Given the volume of publicly funded construction that occurs in Minnesota and that will continue to occur in the future, this amount is very significant. Let me give you an example that demonstrates why this proposal is not good public policy. The Chicago Public Schools recently embarked on a lighting retrofit project that impacted approximately 28 million square feet of space. The value of the 179D deduction at 60 cents a square foot for lighting means that the value of that deduction is about $16.8 million for the firm that designed the lighting project. Assuming that the design firm has a tax rate of about 35%, that means that the design firm, under a proposal like this one, would pocket about $5.5 million, probably more than they were paid by the public entity to do the design. The taxpayers, which funded both the improvements and have already paid the designer to do this work, would receive no benefit from the deduction. We do not believe that this kind of one-sided allocation of benefit is fair or in the public interest. The University of Minnesota has a voluntary program in place that allows us to share the value of the deduction with the designer. We, in turn, reinvest the rebated funds into additional energy efficiency projects at the U. The university program is modeled after successful programs used by state agencies, school districts, colleges and universities in other states. This bill eliminates the university's ability to continue such a program and would prohibit other public agencies from doing the same. While our primary concern with the legislation is financial in nature, we're also concerned about 3 other points as well. First is private use. Our tax department considers a 179D allocation to be a private use of public resources. MMB has strict guidelines for the amount of private use that can be applied to buildings financed exclusively with tax-exempt GO debt. If you haven't already, I would encourage you to obtain guidance from MMB counsel about the impact of this requirement for GO debt-financed projects. Second is legality. In Texas, there was an attempt to pass a similar law to this one, requiring public entities to allocate the deduction. The proposal failed in Texas when it was determined that because the federal government clearly intended to make the program voluntary, the state could not override the federal intent and make the program mandatory. And lastly, the amendment as it currently is written says that the public entity must complete and provide to the designer or designers the 179D allocation in a timely manner. The IRS allocation form referenced by AIA requires that an individual from the public entity sign and attest that, under penalties of perjury, I declare that I have examined this allocation, including accompanying documents, and to the best of my knowledge and belief, that facts presented in support of this allocation are true, correct, and complete. It is not clear in the current proposal if the public entity can refuse to allocate the deduction if it does not believe the requirements of the IRS have been met, or if we just have to find an employee who will sign it anyway. We believe that the status quo, where the decision-making is local and each public entity is allowed to make its own decisions about participating, should remain in place. Thank you.
Thank you very much. Is there any additional testifiers or any questions for the testifier? Representative Horton.
Thank you, Mr. Chair. It's not a question for the testifier, it's a question for you. If the A17 goes on the bill, does it need to go to the tax committee?
Well, Representative Hortman, had you been on time to the committee, you would have known what the motion and we're doing is, I'm just kidding. No, so we're just having this informational, it's actually not being moved before the committee.
The A17?
Correct, it's purely to educate members on the issue. We're not going to be adopting it or taking action on it.
Mr. Chair, if we
Representative Hortman.
would do it on the floor, would we have to then send the bill to the tax committee?
That would be the decision of the tax chair, but I would assume that seeing how it says federal tax deductions in the title of the section, the tax chair would want it, but you'd have to ask him. But presumably, no, this is not a procedural maneuver to amend it onto this bill. This is purely to inform members of the committee.
Thank you.
Thank you. Any other questions from Representative Wagenius?
Thank you, Mr. Chair. It's 2 questions. One for you. Are you going to have MMB counsel testify on this proposal?
Representative Wagenius, we're certainly at the portion where we're going to solicit public testimony. This is a public hearing, but I have not reached out to them in an affirmative way.
So do they know that, other than this just being posted, do they know that this is a potential?
Representative Wagenius, I don't know if they're reviewing the bills or they're reviewing the amendments or watching on TV right now. I do not know what their level of knowledge is about it.
Okay. So
Representative Wagenius.
thank you, Mr. Chair. So we don't know whether they know about this proposal or not, and you haven't invited them specifically. So
Correct.
Okay. But then, can I ask a question of the testifier?
Of course.
So if I read this, what's going on here, one possibility, if this were to pass, that there would be less incentive for energy efficient design. Could that be true?
Mr. Swanson.
Mr. Chairman, Representative Wagenius, to the extent that the owner can realize savings to themselves to help pay for additional improvements, we do have an incentive to make the building more efficient if we get some of those savings back and have additional money to put into the project. So I would say yes, that we would have less incentive to do more energy efficiency work if this bill would pass. Now, the university does, through our own design standards, do energy efficient work anyway, so we already try to do this, and our direction to the designers is to make the buildings efficient, and that's what we're already paying them to do. I would also add one additional comment to what was raised earlier, and that was to the question of federal government doing this. The Housing and Urban Development at the federal government has a similar program to what we're proposing, and base commanders in the Department of Defense have the ability to put additional requirements like we proposed on designers doing work for Department of Defense.
Representative Wagenius.
Got my answer, thank you.
Any other questions from members of the committee? Mr. Swanson, I have a question. So when a private firm bids on this, perhaps the firm is assuming that the tax deduction is part of their bid process. This is going to be one of the offsets. So in fact, they come in at a lower price than what we'll call the retail price. In that situation, how do you resolve that conflict where the private sector would say, well, no, you are getting this benefit. You're actually getting a lower price. You're getting additional, you're retaining money that you're able to spend in the way that you want, but we've built that into the price of it.
Mr. Chairman, at the time a firm is bidding, the design firm is bidding on the project, which those are generally negotiated kind of bids, or negotiated proposal responses, it is unclear, because the project hasn't been designed yet, what the value of that deduction would be. And the firm who's doing the proposing, generally the architect, may not be the firm that actually ends up qualifying for the deduction. It could be the lighting designer, it could be the HVAC designer. So it is unlikely that the designer, and I'm not the designer, but I'm sure they could speak to it as well, would discount their price at the front end of the project on the hope that several years from now, when the project is complete, the as-built have been turned in, their firm will actually be able to realize a certain amount of the deduction. It's only at the end of the project, when the energy models have been completed and the as-built drawings are done, that the actual value of the deduction can be calculated.
Okay. Representative Fabian.
Thank you, Mr. Chair. So when you do a large project on campus, and you're looking at different architectural firms, how do you reach a decision on which firm to use?
Mr. Swanson.
Chair Garofalo, Representative Fabia. We currently use the State Designer Selection Board for our largest projects. So we go through the Department of Admin's selection process, which is a qualifications but not fee-based process.
Representative Fabian.
Thank you, Mr. Chair. So in your discussions with them, if this is in play, couldn't this become a part of the negotiations that's involved with them so that you could recoup those through just the fees that they charge, not through getting some sort of a rebate on the tax credit, but just in the charges that they assess for the project?
Mr. Swanson.
Chair Garofalo, Representative Fabian. This legislation would prohibit us from being able to do exactly what you just proposed. We believe that it's more fair and more transparent to wait until the end of the project, do the engineering analysis, have the third-party consultant come in and determine the value of the deduction, work with the individual firm and find out their tax rate and figure out what the actual cash value of this would be to a particular firm, and then split the difference 50-50.
Any other questions for the testifier? Thank you. Rebuttal testimony. Welcome back to the committee.
Thank you, Mr. Chair. Committee members, a couple of things to note is that this situation plays out differently depending on the entity that we're talking about. The U handles this one way, which is the split approach based on the final amount determined to be the appropriate deduction at the end. Other entities are bringing this into the negotiation on the front end of the contract. Right. Some are building it into the RFP. My understanding is that that is being done with some of those legal concerns in mind in terms of fairness and antitrust and anti-competitiveness. So it's playing out in different ways, but it has a similar effect of redirecting a federal tax deduction that was meant for the private sector to be one that is of direct benefit to governmental entities. And it seems quite similar to the situation at the federal level with the GSA that was turned back, that was no longer allowed. You know, the term kickback was used In that context, I'm not sure I understand how different this situation is that in that regard. So overall, our concern is the legislative intent and how that's playing out in Minnesota versus other states around the country.
Mr. Swanson, did you want to add any additional information?
Chair Garofalo, I think we could argue the intent. The original intent of the law was for private commercial building owners. That makes sense. If you're a private owner, you should, and you're going to recover the benefit in your taxes, there used to be an incentive to put the money back into your building. Nowhere in the legislation does it say that for the public, the intent is to give the money to the architect. And if you look at the original author of the bill, who was Senator Bingaman from New Mexico, he said, to reduce the cost to taxpayers of the project and provide savings similar to private owners making identical investments in building efficiency. So the original federal author of the bill intended for public owners to be able to recoup some of this benefit to meet the objective of the legislation, which was to incent energy efficiency in buildings, in public buildings.
Any other questions for our testifiers? Okay, this is a public hearing. Are there any members of the public who wish to testify or voice concerns with the discussion on the A17 amendment? All right, seeing none, we'll close the public comment portion for this. Any closing comments from either one of you?
Thank you.
Thank you.
Thank you very much, members. All right, so again, members, what we're going to do now is we're going to vote to get we're going to have the delete all amendment put in front of the committee. So the chair will move the AN-A09 amendment to be before the committee. All those in favor, please signify by saying aye. Aye. Opposed, say nay. Motion prevails. The AN-A09 bill is now before the committee. So members, what we're going to do now is go to our nonpartisan research, and they will provide us a brief overview. I think what we'll do is we'll stop after a couple articles. We'll take questions just kind of in chunks as we go through the nonpartisan research, or if they need a break to grab a sip of water or something. So we'll start. Ms. Newman, are you going to kick us off?
Mr. Chair, I certainly can, unless you would like Ms. Hendricks to go through the spreadsheet first with the appropriations.
Yeah, we can do that. Ms. Hendricks, are you ready to? Okay, so let's, members, go to your, looks like my spreadsheet I have here is April 14th, dated 6:49 PM. So,
Correct.
Ms. Hendricks, please proceed, and then we'll take questions from members after that.
Mr. Chair and members of the committee, as the chair just mentioned, I'll be working off the spreadsheet that is dated April 14, 2016, 6:49 PM. It's divided in three sections. The first one is the summary of general fund impact. You'll see on lines 2 through 15 the total appropriations to the agencies in the committee's jurisdiction. This is total expenditure, so the base funding as from the February forecast with the changes that the bill makes. I won't go through every single line, but you can see on line 15 the total for the biennium now is $450,405,000. There's two general fund revenue changes starting on line 17 that have to do with the voice over internet protocol policy language in the bill. This reduces assessment amounts in both the Commerce and the PUC. And that leads to a general fund impact on line 26 for the biennium of $451,156,000, which is a difference between the forecasted base and the bill is $11,665,000, which is the committee's target. On line 30, the detailed overview of the change items starts. So for every department, there's the changes listed in the bill. I'll go through them. On line 35, a one-time reduction in the Minnesota Investment Fund of $12 million that brings the base, and in the tails a $10 million reduction in each year. So that brings the base for this program to $5 million a year. Minnesota Job Creation Fund, a one-time reduction of $8.5 million in 17 and $5 million reduction each year in the tails, which brings the base for this program to $7.5 million a year. redevelopment grant program at $1 million a year, child care business manual development at $100,000 in fiscal 17, and then grants, accompanying grants at $500,000 in fiscal 17. Then there's 3 reductions for the Upper Minnesota Film Office, the Minnesota Film and TV Board, and Snowbait. That total a little over $1.8 million. Workforce Housing Development Program, $5 million one-time appropriation 17. Going to the next page, the Mille Lacs Economic Relief Program, $2.29 million in fiscal 17. The Neighborhood Development Center at $1 million from the Workforce Development Fund. Enterprise Minnesota, a $500,000 one-time appropriation from the Workforce Development Fund. Then a statutory appropriation from the Small Business Investment Tax Credit Administration account. This is for some IT-related activities or work with Indeed that has to do with an expansion of who would qualify for the Angel Investment Tax Credit. Then you can see the totals for business and community development divided by fund. Going on to the Workforce Development Fund, subdivision with Indeed, construction career grants, $1 million one time in fiscal 17. Youth at Work competitive grant program at $400,000. Then a set of appropriations from the Workforce Development Fund for Ujamaa Place, $600,000 one time. Latino Communities United and Services, $800,000 one time funding. Twin Cities Rise, $600,000 from the Workforce Development Fund. The YWCA in Minneapolis, $500,000 one time appropriation. On line 63, this was an existing appropriation in from 2015 session laws, and so the name is change of the organization. This is why you'll see here it's the St. Cloud Somali Youth Organization, and the appropriation was made one time rather than ongoing as it was in the 2015 law. So you'll see the reduction in the tails, but they still receive $50,000 each year in fiscal 16 and 17 from the Workforce Development Fund. Under vocational rehabilitation, on line 68, one-time appropriation of $500,000 to the Minnesota Centers for Independent Living. For the services for the blind, on line 71, a one-time appropriation of $200,000. Then under broadband, an overall amount of $15 million in fiscal 17 and $25 million in fiscal 18 to the Broadband Development Grant Program. And then you'll see a kind of set-asides or carve-outs for 3 different types of grants. So that's what the bracketed amounts mean here. It's of that $15 million, $5 million for economic development broadband grants, wireless grants, $1 million and $500,000 for low-income area assistance broadband grants. So that concludes deed. On the final lines, 82, 83, 84, you'll see the totals for the department. Going to the next page, Minnesota Housing Finance Agency, one-time $5 million reduction in the Economic Development and Housing Challenge Program, and $250,000 one-time for Landlord Guarantee Fund pilot, a pilot program. Under Explore Minnesota Tourism, 2 appropriations from the general fund. The first one, $300,000 for Mille Lacs Lake tourism promotion, and $500,000 for a pilot project to fund and secure major events. On line 96, under Department of Labor and Industry, $250,000 ongoing from the general fund for the apprenticeship program. Line 104, under Bureau of Mediation Services, a reduction in the appropriation to the Public Employment Relations Board of $125,000, and that's an ongoing reduction. Under Department of Commerce, starting on line 109, on line 113, you'll see the accompanying reduction in the general fund appropriation to Commerce for telecommunications. That matches the reduction in the assessment amount that was under the general fund revenue on page 1. So $376,000 in fiscal 17, and then $451,000 in fiscal year 18, and $527,000 in fiscal year 19. An ongoing appropriation of $100,000 to the Energy Regulation and Planning Unit. Line 119, $125,000 ongoing appropriation for the insurance fraud civil penalty staff. And you'll see exactly the same label on line 120, but then the bracket amount of $125,000 ongoing. And this is again, a carve-out or set-aside in 2015 laws from the budget that was passed last year under insurance. $125,000 is set aside for the same activity. So there's one-time new or ongoing new money of $125,000 and then a set-aside of $125,000 in existing appropriations. Under the PUC, on line 123, an increase for additional staffing and rulemaking, $112,000 in fiscal 17, and then $225,000 ongoing each year. And then on the line 125, you'll see, again, the appropriation reduction that I just talked about under commerce that has to do with the VOIP deregulation. So again, it matches the revenue reduction for the PUC on page 1. Finally, the last appropriation on line 128 to the Public Facilities Authority for Lewis and Clark Regional Water System Project of $11.5 million in 17. On the last page, you'll see one non-general fund revenue change. This again has to do with Representative Loon's bill that expands the type of investors that can qualify for the Angel Investment Tax Credit. This would bring in a small amount of $7,000 in fiscal 17 and $2,000 each year in 18 and 19 for registration fees. That is in the special revenue fund. And then a summary of the direct appropriations by fund. That concludes the spreadsheet.
Thank you. Any questions for Ms. Hendricks? Representative Mahoney.
So, Mr. Chair, and whomever, on line 128, Lewis and Clark Regional Water System Project, is that money coming out of the Public Facilities Authority, or is it coming from general funds? Is it moving something up the list? Just a little explanation, and we can talk more about it. As I think about it, I want to have an idea of what's going on.
Ms. Hendricks, do you want to answer it, or otherwise I can answer it?
Representative Mahoney, it is a one-time general fund appropriation to the PFA, so it is new money and for a grant to.
Thank you.
Yep.
Representative Mahoney. Any other questions from members of the committee? All right, Ms. Newman.
Mr. Chair and members, I will take you hopefully briefly through the bill. And Article 1 is the appropriation section, and I'll just touch on sort of the high points on that. On page 1, subdivision 2 at line 23 is where you begin the revenue or the savings generators in the bill. That's the $12 million reduction in the appropriation for the Minnesota Investment Fund, and that goes over onto page 2 where the base is fixed at $5 million beginning in fiscal 18. Line 2.4 is the other large reduction, which is the $8.5 million in the general fund appropriation for the job creation program. And then on line 2.9 is where the base for that program is fixed at $7.5 million a year beginning in fiscal 18. The other, and Ms. Hendricks went through the appropriations quite sufficiently. I'll point on the bottom of page 3 at line 31. These are the grants to address childcare shortage. This was a bill that was heard in this committee. This language differs a little bit from that in that these grants are targeted outside of the 7-county metro area. Mr. Chair and members, on page 8, the broadband development grants, and Mr. Eloff may want to walk you through this language.
Mr. Eloff.
Mr. Chair and members, this language starts on line 14 of page 8, indicating that $15 million in fiscal year 2017 is from the general fund to be deposited in the broadband fund account, and it continues to say the base funding for the program is $25 million in fiscal year 18, both one-time appropriations. And this is broken up in a couple of different pieces. Paragraph B says that 1/3 of the grants are to expand access to broadband that the commissioner determines will help create or retain jobs in greater Minnesota, and provides that there are 3 requirements for grants funded under this paragraph, that they can't fund more than 22% of the total project costs, that grants under this program utilize federal Connect America funds to supplement the state funds, and at the top of page 9, that a majority of the grant must be expended in a city with a population of 2,000 or greater. Paragraph C on line 7 on page 9 sets aside $1 million for grants to expand broadband service in unserved areas via either fixed or mobile wireless technology. And paragraph D sets aside $500,000 for grants that would expand broadband service in areas that contain a significant proportion of low-income households.
Ms. Newman.
Mr. Chair and members, then continuing on, Section 3, the Housing Finance Agency, if you turn your attention to line 34 on page 9, this is where $5 million is transferred from the Challenge Program to fund the deed appropriation for workforce housing back on page 3. So that's $5 million. And on page 10 is family homeless prevention. Tourism, the other change, members, is on page 11. We'll move to the Bureau of Mediation Services. This is where the reduction of $125,000 related to the PERB funding shows up in the Bureau of Mediation Services. On page 12, section 9, is the Public Facilities Authority, and this relates to the question Representative Mahoney asked. This is the $11.5 million general fund appropriation for the Lewis and Clark project. Page 13, section 10, and that goes over, the change is on page 16. This is the change. Last year there was an appropriation to the St. Cloud area Somali Salvation Organization. This is redirecting those funds to the St. Cloud Somali Youth Organization. Last year's appropriation was an ongoing appropriation, and the new rider language makes this a one-time appropriation. Then on page 19, members, section 11, this is where $125,000 of the Department of Commerce's base is earmarked for insurance fraud enforcement beginning in fiscal 17. Article 2, we begin the policy language in the bill. Section 1 on page 19 and section 2 on page 21 through to the top of page 22 is cleanup language related to the Lewis and Clark appropriation, the bonding appropriation from last session. And this is, I am told, technical language that will allow the bonds to go out as they were intended last session.
Ms. Newman, at this point, you can grab yourself a drink, and we'll see if anyone has any. What I meant by drink, I meant like something to drink, not like an alcoholic drink. I didn't mean that. Is there any questions, members of the committee? That'll come tonight, yeah. So please continue with your testimony, or with your presentation.
Mr. Chair, this section 3 is the host community grant program, and this just expands the use of that program. This was Representative Peterson's bill, and it's the redevelopment and development area, and it establishes some new goals and provides a definition of long-term economic development. Section 4 is also from Representative Peterson's host community grant proposal. Section 5, members, this has to do with the prevailing wage provisions in 116J, and this makes a change in the standard for housing construction, and instead of the $100,000 threshold applying to a single project site, this would change it to per housing unit. Section 6, which starts on page 23 and goes over to page 24. This is Representative Loon's Minvest program, and the language at line 11 would allow those securities to qualify for the to participate in the Angel Investment Tax Credit Program. Section 7 on page 24 is the pay for performance grants, and this increases the loan and grant and qualifying thresholds. Section 8, beginning on page 24 and going on to page 25, is also a portion of those pay performance grant changes, and you can see on page 25, lines 15 and 17, the income and asset thresholds are increased. Section 9 is Representative Knobloch's bill that would add the Commissioner of Human Rights to the Urban Initiative Board. Section 10 is the origin of this was Representative Erickson's Mille Lacs Economic Relief Program, but this is a fairly significant rewrite of that language to establish job goals, measurements, oversight by deed. It puts limits on the grant amount at $50,000, limits on the loan amount at $100,000. Specifies that loan payback goes back into the Minnesota Investment Fund disaster contingency account. It requires fairly specific criteria for the loans and grants, and that the commissioner has to approve those criteria that Mille Lacs County would set up. And if you look...
Representative Mahoney.
Just as having read the bill last night, could you or Ms. Newman explain what the Minnesota Investment Fund disaster contingency account is? I mean, I only had one computer. I couldn't keep the session law up. And
Ms. Newman.
Mr. Chair and Representative Mahoney, this is an account that was used pretty heavily with some of the flood disaster reliefs in the past several sessions, and it is Deed can speak to the details of it, but it is a statutory account of Minnesota Investment Fund and other money that is for rebuilding and aid for disasters, in response to disasters.
So Representative Mahoney, it's the fund, so we don't have a special session every time there's a natural disaster.
that's what I was going to ask, Mr. Chair. Is this the Pulowski rework of this disaster relief fund?
Ms.
And
Newman.
how much is in it? And I guess that would be for Ms. Hint. And we can talk to that later. I know we're just going through the bill.
Yep.
She can catch up with me later.
Okay. All right, so we're still on Article 2?
Yes. Page 27, line 23, subdivision 4 requires the monitoring that the Mille Lacs County will be the fiscal agent for this Mille Lacs assistance. And it requires the county to establish performance measures, and it lists some of the components that have to be in that list of measures. And then if you look on page 28, paragraph B, this is where the Commissioner of Deed must monitor the compliance of the county with following through on those performance measures. Subdivisions 5 on the Mille Lacs specify that the business subsidy requirements that are in statute don't apply in this case. Subdivision 6 sets aside 1% of the amount appropriated that Deed could use for administrative costs. Section 11 on page 28 is the repealer of the snowbait program.
Mr. Weeks, Article 3?
Article 3 deals with labor and industry. It has only one section, starting on 2819. This is a change to the AWARE program. Currently, the list of industry classifications for requirement for participation in the AWARE program changes every 2 years. This just changes that, expands that to every 5 years, so there's not as much in and out. And then Section 2 is a repealer of the child care unionization language in the PELRA statute.
Is Ms. Mullen here?
She had to go to.
Okay, do you want to cover Article 4? Ms. Newman?
Mr. Chair and members, Article 4 is the housing article, and the two sections in here are the Family Homeless Prevention Program, which I think, it's the governor's rec, but I think Representative Clark carried it, and it increases the age from 22 years to 24 years for people able to participate, and also adds a tribe or a group of tribes to the set-aside language.
Mr. Weeks, back to you.
Then Articles 5, 6, and 7 all have to do with workers' compensation advisory council proposals. So these have all been vetted through the Workers' Compensation Advisory Council and that rigorous process. And I'll do really high-level overview. Article 5 deals with things relating to the Workers' Compensation Court of Appeals. These are mostly technical changes as well as a few conforming changes to bring statute language clearly in line with current practice. If you move on to page 33 at the top, 33.1, that's Article 6. These are proposals brought forth by the Workers' Compensation Department of the Department of Labor and Industry. These are some technical issues mostly related to the attachment of electronic documents to in a system that by which insurance companies, payors, and hospitals and healthcare providers process claims and payments. And there were some problems with documents being attached electronically. This standardizes it, and that's what all those long streams of letters and numbers mean. Move on to 35.28, Article 7. This is the workers' compensation litigation-related proposals. The most notable of this was a response to a 2015 Minnesota Supreme Court case. That was the Sumner case, which changed the longstanding understanding of interested parties about when physical presence or telephone presence was required at an intervention into a workers' compensation dispute. Typically, people hadn't been required to show up at these things, even by phone, and none of the relevant entities were structured to have staff to do this. There could be multiple of these a day. So these are all changes to effectively overturn that Supreme Court decision and make it clear when entities, which include unemployment insurance, other state agencies, Department of Human Services, et cetera, as well as private insurers, when they have to actually be physically present or present on the phone. Moving on to the next article, which is Article 8, and Articles 8, 9, and 10 all have to do with unemployment insurance, and these were all vetted by the Unemployment Insurance Advisory Council. Article 8 deals with policy. There's nothing earth-shattering in there, some minor fixes. And moving on to
Mr. Eloff takes Article 11, right?
Yeah, Article 11 on, yeah.
Yep.
Yeah.
So, Mr. Eloff, Article 11?
And 9 and 10 are essentially the same. Yeah.
Thanks.
Mr. Chair and members, Article 11 begins at the bottom of page 65. Actually, the language starts at the top of page 66 with, this is Representative Sanders' bill, House File 776, essentially deregulating voice over internet protocol voice service. At the top of page 66 are two definitions, and Section 3 in the middle of the page specifies that VoIP shall not be regulated by the state, except exemptions in subdivision 2 says that VoIP service will continue to be subject to the telephone assistance plan, which subsidizes phone bills for low-income persons, also subject to the Telecommunications Access Minnesota program, which provides devices to persons with communication disabilities to enable them to use telecommunication services. Article 12 is the broadband development article. Section 1 is merely a technical change on some definitions. Section 2 adds language to the broadband border-to-border grant program. What Section 2 does is require that prior to the time that applications are due to the Department of Employment and Economic Development, the Commissioner must publish any specific criteria and quantitative weighting schemes or scoring systems that will be used to rank applications. So applicants know that information well in advance of submitting applications. Section 3 on page 68 provides an incumbent right of first refusal, requires the applicant for a grant under this program to submit a copy of that application to the incumbent broadband service provider in the area where the project is to take place, and allows the incumbent to specify in writing to the applicant that it will, that intends and commits to begin construction on a broadband service project within 12 months of the date on which grant awards are to be given, that will extend or upgrade broadband service in that area at or greater than the state broadband speed goal. If that happens, the applicant is required to withdraw their application for the grant. Subdivision 6 at the top of page 69 indicates that within 90 days after the first grant is awarded, the Commissioner shall notify in writing each applicant that was unsuccessful in obtaining a grant and specifying the reasons the application was unsuccessful. At the bottom of that page, Section 5 requires the Office of Broadband Development to place on the department's website basically the results of any quantitative weighting scheme that was used for applications the previous year, and the grant amount requested for each grant, and the grant amount awarded for each grant, if any. Section 6 on page 70 places in statute language that has, I think, heretofore been in riders only, requiring the office to each year contract to obtain broadband deployment data from service providers in Minnesota, and to use that data to construct maps that are available to the public showing where services are available and at what speeds. Section 7 on page 70 exempts the prevailing wage requirement for the repair of last-mile infrastructure for broadband projects. Section 8 at the top of page 71 updates to 2015, or from 2015 to 2020, the state's universal access and high-speed goal, and Section 9 also updates the state's goal from 2015 to 2020. Article 13 is the energy article, beginning in the middle of page 71, and Sections 1 and 2 are from Representative Garofalo's House File 3569 as modified. The meat of the article is actually on page 74 at the top, and what it provides is that currently under current statutes, Xcel Energy is required to pay a certain amount per year for each cask stored at Prairie Island and Monticello with nuclear waste. This language would change that to say that a cask that over time, when $10 million over time has been placed by Xcel in the Renewable Development account, that is the end of responsibilities for that cask. So it sets a ceiling on the amount of money for each cask that is stored at Prairie Island or Monticello. Section 3 is Representative Fabian's House File 3508, which increases the number of members of the Public Utility Commission from 5 to 9, 8 of whom represent the state's congressional district. This language has been modified to meet the concerns of members when we first heard this bill, that there would be an even number of members on the commission. Under the transition language on the top of page 75, there is now an odd number of commissioners each year. Section 5 on page 75 is Representative Garofalo's House File 3570, which allows electric cooperatives that have elected to be subject to price regulation by the Public Utilities Commission to have a somewhat abbreviated rate case process. On page 78, Community Solar Garden, this is Representative Swedzinski's bill, House File 3074. The language on page 79 at the bottom has been modified to meet the concerns that were raised when we heard this bill, Mr. Chair, regarding the model that there was an assumption that the model had upfront payments, and this language has been amended to remove language that dealt with upfront payments. On page 80 is House File 2542. This is Representative Garofalo's bill, this in the next section, to remove pipeline facilities essentially from the Conservation Improvement Program. Their gross operating revenues and their sales will no longer be considered in setting the energy savings goals of the utilities that serve them. Moving to section 9 at the bottom of page 84, this is Representative Baker's House File 2486, and it modifies the energy savings goals to allow municipal utilities or cooperatives to request the Commissioner of Commerce to adjust their annual energy savings goal, and requires the Commissioner to approve that request. It also allows public utilities to adjust their energy savings goal as well, but they can't do that below a level of 1% per year. Language in the middle of the page also allows both public utilities and municipal utilities and cooperatives to count energy savings from electric utility infrastructure projects towards their energy savings goals. On page 86, section 10 is Representative Garofalo's House File 2543, which exempts interstate pipelines that begin and end outside the state from being required to get a certificate of need in Minnesota. Section 11 on page 87 is Representative Baker's House File 3251, which allows an increase in the assessment for the Propane Education Council. And finally, Section 12 on page 87 is language that prohibits state agencies from expending state funds to develop a plan to send to the Environmental Protection Agency to comply with the Clean Power Plan until the legal case challenging the EPA's authority to require such plans of state has been settled. And that's it, Mr. Chair.
Thank you, Mr. Illiff. Any questions from members of the committee for nonpartisan staff? Representative Mahoney.
Just for nonpartisan staff, I was going to ask you how many more poison pills you could put in.
Which staff member do you want to ask that question to, Representative Mahoney?
Mr. Kennedy?
6 more. Okay, seeing no other questions from members of the committee, we'll move to public testimony. First on the list, Becky, and thank you again. If you signed up in advance, thank you for contacting us. If you haven't yet, our very loyal and studious pages are, where are they?
They're well hidden.
Okay, hi. Okay, so I'll just make sure you sign up with them so we can get you on the list. We'll start with Becky Roloff from the YWCA. Peter Nelson is on deck, and Otis Zanders, are you here? All right, you'll be, you're in the dugout. So, welcome to the committee. Please state your name for the record.
Well, can I move my chair up a little bit?
No, you're not allowed to move your chair at all, no.
Maybe I'll-
I'm just kidding.
Well, it's just a good thing I'm tall. Okay, we'll stay right there. Thank you so much for the opportunity today.
If you could,
And-
please state your name for the record so formally.
I'm Becky Roloff. I'm the president and CEO of the YWC of Minneapolis, and we appreciate inclusion in this bill. I wanted to just review a few of the highlights of why we think this is a very good investment for the state of Minnesota to make. The mission of the YWC, as you know, is the elimination of racism and the empowerment of women and girls, and we do that in many ways. One of the most visible ways we do it is through addressing disparities in early childhood education. And the Child Development Assistance Program is designed to address these income disparities as well as providing professional certification and a career pathway for low-income Minnesotans. How did this come about? The impetus for this program was a comprehensive review that the Wilder Foundation did. They were very complimentary of our current training program, and they identified a need, which was how we would get more qualified people in startup child care centers, especially in new American communities. They urged us to consider to find a way to support early quality learning in the community. The target population for this money is low-income workers, particularly women and new Americans. Important to note, if you're not familiar with early childhood in depth, is that this certificate is recognized nationally. NACE recognizes this, Head Start recognizes this. It recognizes high school equivalency education from other countries as a prerequisite to the program. And sometimes you can imagine that's a barrier. It can be used in any setting. This is good in a home licensed setting, in a center-based setting, and at places like Head Start. So it's a very versatile, flexible certification. We believe we are uniquely qualified to deliver this training. Half of our teachers in our early childhood program identify as people of color. We have 6 sites across the Twin Cities to serve as training sites. We need to make no capital investment to be able to do this, and we're recognized nationally for the quality of our training. We currently do this for 18 of our own employees. This investment of $500,000 would open the program to workers across the Twin Cities. We believe we could ramp up to 100 within 2 years. In summary, your support contributes, I think, to 3 wins for Education Minnesota. Number 1, it's another piece of eliminating the achievement gap. Number 2, it helps down the road increase the diversity of teachers because you can go from a certification ultimately to a 2-year certification to a college degree. And lastly, improves the quality of early childhood education across the state of Minnesota.
Thank you. Any questions for the testifier? Thank you very much for your presentation.
Thank you.
Mr. Nelson, Peter Nelson, and Otis Sanders, you're on deck. Welcome to the committee. Please state, can we get the testifiers a new chair, maybe switch them so that...
All right. Like your feet.
There we go.
Is it better? Welcome to the committee. Please state your name for the record.
Thank you, Mr. Chair, members of the committee. My name is Peter Nelson, and I'm the Vice President and Senior Policy Fellow for Center of the American Experiment. And I'm happy to be here today to talk a little bit about this bill. Overall, I think there's a lot of positive elements in this bill, and I just want to highlight a few of them. Center of the American Experiment generally comes to work these development questions with the idea that we shouldn't be picking winners and losers through our state programs. That to the extent we are providing funds to workforce development, they should be general funds, sort of focused on general programs that cover a broad group of people, a broad group of workers, and to the extent we are subsidizing businesses, businesses should be, any business should have access to these subsidies. It should be a fair process where we're, again, not picking winners and losers. And when I look at this bill, I'm very pleased to see that there's a lot of elements that sort of reprioritizes a lot of what we're spending our money on away from these programs that pick winners and losers, programs like the Minnesota Investment Fund, the Job Creation Fund, and moving some of that funding towards other programs that really do have demonstrated a positive impact, programs like Twin Cities Rise and some of these other general programs that anyone, depending on whatever criteria we set up, anyone who meets that criteria qualifies for. And I think that's very important, that anyone who qualifies under criteria should qualify for state funding. So that's a very positive element in this bill. And I do want to just reference something. A few years ago, a company called Shutterfly was attracted to the state of Minnesota. And this kind of goes to the picking winners and losers. We picked them as a winner. One of the questions you always have to ask yourself, would a Shutterfly have actually come here anyway without that funding from the Minnesota Investment Fund? And I think the answer is yes. I looked at the tax policies in Wisconsin and the tax policies in Minnesota. Minnesota actually had a very attractive tax policy for Shutterfly. I don't believe we ever needed to spend money to attract them here. Excuse me?
I'm going to write that down.
Please do write that down. Minnesota is generally a high-tax state for almost all businesses, but manufacturers are our particular case because we don't have a throwback rule, which means we don't charge a tax to sales that go out of the state if it's not taxed out of the state. Because we don't have this throwback rule, it's a pretty attractive climate for a lot of businesses. And so I don't think it was necessary to do that. I don't think we needed to pick that winner. If we just had a general system such as the Angel Investment Tax Credit, if we just had a general system where you qualify under it, the Research Development Credit, I think that's a better approach. So I'm pleased to see all of that in here. Second, I want to talk a little bit about the Renewable Development Fund. This is a program that's been on the books, I believe, since 1994, way back when we didn't have renewable mandates. We didn't have a lot of these other green energy requirements on the books. And to me, I think this fund has outlived its usefulness and is no longer necessary. So I'm very pleased to see these provisions that suggest it's going to go away. Maybe not completely, but certainly curtails a lot of the funding that goes there, because this also has a second problem that I see in our energy policy, and that is too often Xcel Energy is picked on as the place where we're going to make requirements that other people in the state don't have to follow, and that's just not a fair policy process. And I want to lastly talk a little bit about the Clean Power Plan. I'm very pleased to see that the Clean Power Plan will need to come back for approval through this bill. And I'm very, very pleased to see, I really think that we should just stop putting money right now into the Clean Power Plan, because right now the Supreme Court has put a hold on that. And one of the reasons they put a hold on the Clean Power Plan is because we had some recent experience with not putting a hold on an energy bill. We had mercury rules that were up, and we didn't put a hold on that. And the country's utilities invested a lot of money in updating their mercury systems, capture systems, and when at the end of the day, that rule got overturned by the Supreme Court. And all of that investment was really for naught. And despite what you think about the policy, it was not required by the federal government at the end of the day. And we very well might see at the end of the day that the Clean Power Plan gets overturned by the Supreme Court. And if that happens, then we will have spent a lot of money unnecessarily when right now we already have more than enough, I think, going on in Minnesota when it comes to green energy. With that, I will leave you open to questions.
Questions from members of the committee. Representative Hortman and then Mahoney.
Thank you, Mr. Chair. I was wondering if the testifier could just name all the utilities in Minnesota that store nuclear waste here.
I assume you want to exclude the military?
I said utilities.
Okay. Mr. Nelson.
Mr. Chair, Representative Horton, that would be Xcel Energy. That is the one utility that stores nuclear waste, and we have nuclear facilities in the state that have given us reliable baseload power that benefits the state. I don't see why having nuclear energy that provides reliable baseload power should single Xcel out for having all these extra requirements within our system.
Representative Hortman.
Thank you, Mr. Chair. Well, you speculated that there was no reason that this particular utility was treated different than the others. And I would say you just articulated the reason that this utility is treated differently than the others, especially with respect to the Renewable Development Fund that was part of the deal that allowed them to store the waste here.
Representative Mahoney.
Mr. Chair, and to Mr. Nelson, I'm shocked because today I'm going to have to stop deleting all those Centers for the American Experiment before I open them. We agree on a couple things, that the business climate in Minnesota is attractive, and that XL gets picked on, whether, it's one thing or another. So I'm just shocked at that. I will say that the $20 million out of the MIF and Job Creation Fund for $600,000 to one of the particulars programs that you mentioned is a little bit of a bad deal for the rest of the state. And the mercury piece, well, you've ever heard of the statement of mad as a hatter? That's where the mercury and lead was used on the hats. And so it's not a bad idea that we got rid of mercury. Did you think we needed to have more mercury in the environment there? Is that a position of the American experiment or whatever it's called?
Mr. Nelson.
Mr. Chair, Representative Mahoney, my position and Southern America's position is not that we expand the output of mercury from our power plants.
Oh, okay, so I guess we got three of them here. So that's it. Thank you, Mr. Chair.
Representative Wagenius.
Thank you, Mr. Chair. Let's go back to mercury here for a minute. What I understand or understood that you were doing, and I just want to make sure I got it right, that you're making an analogy between investment in mercury reduction and an investment in renewable energy. And am I getting that right?
Mr. Nelson.
Mr. Chair, Representative Wagenius, no, that's not exactly what I'm doing. I'm using the mercury rule as an example where the Supreme Court ultimately ruled that the Obama administration had overstepped its authority and ruled that they did not have the authority to implement that rule, yet it took so long for that opinion to come down that pretty much every state in the country had already implemented the rule, and so their opinion was in many ways moot at that time, and all of these investments had been made that weren't necessary to be made under federal law. And we're going to possibly see a very similar thing happen with the Clean Power Plan.
Representative Wagenius.
Okay, so what you're saying is the mercury reduction wasn't necessary under federal law, but for children, it probably was a really good thing. Not?
Mr. Nelson.
Mr. Chair, Representative Wagenius, I'm not questioning the wisdom of the policy, whether it was good or bad. What I'm questioning is the fact that the federal government implemented the policy without the authority they needed to implement it. And that appears to be what they're doing right now with the Clean Power Plan.
Representative Wagenius.
So then, using the analogy, then any investment in conditional investment in renewables is kind of to naught, same as the investment in mercury reduction was to naught.
Mr. Nelson.
Mr. Chair, Representative Wagenius, at this point, I would say yes. We are not for investing further in renewables in this state. In fact, we have serious questions about whether we're going too far under state law, serious questions about the cost that's putting on our entire energy system here in the state, because we used to have very competitive energy rates, and that was one of the few business costs that made Minnesota stand out as a good place to locate. We aren't necessarily a low-cost electricity provider anymore, and we have serious concerns that the green energy policies that we put in place are behind some of that. And we also have serious concerns about reliability issues of putting as much wind on the grid as we have right now. The wind that we have on the grid right now is resulting in negative pricing. It gives us electricity when we don't really need electricity on the grid. It's a problematic energy source from our perspective.
Representative Wagenius, any follow-up?
Well, no, I think the witness has explained what he's thinking.
Seeing no other comments, thank you for your testimony.
Thank you.
Next is Megan Christensen and, no, excuse me, it was Otis Zanders, Megan Christensen, and Terry Manson. You're on deck. Welcome to the committee, sir. Please state your name for the record, and please proceed with your testimony.
Mr. Chairman, members of the committee, my name is Otis Zanders. I serve as the CEO of Ujama Place. On behalf of the Ujama Place staff, our participants, supporters, and partners, I just want to thank this committee for their favorable consideration of House File 2440, our employment bill. We're very honored that you've taken into consideration the needs of Ujama Place. Before I begin, I would like to just give a special thanks to Representative Moran for being the author of this bill, and also for Representative Mahoney for his heavy lifting, confidence in this program, and bringing it forward to this committee. The young men that we serve at Ujama Place have multiple barriers for stabilization and for being considerable citizens in our community here. And arguably, one of the greatest barriers that they face is employment. This appropriation will allow us to expand on our job prep program that's dealing with young men that don't have a strong work history. Some come to us being unemployable. The prep program that we allow to expand our classroom presentation that deals with interviewing skills, job prep, housing, interviewing, etc. So an additional part of this bill will allow us to expand our internship program. One thing we've had favorable success with is going beyond the ban the box. Young men that we serve with a lot of times are given opportunities, but because they don't have to put down their criminal background, but once the background check catches up with them, we find out that they're still being dismissed from employment. We feel that through this process of having paid internships, we allow to lower the risk for the employment community. By doing these paid internships, we'll be giving young men up to 6 months of employment prep on the job to determine their viability, workability, and dependability to be excellent employers. Additional part of this program that we have also is to expand our construction trade program. This program that we have now has been leveraged greatly by the charitable community that allowed us to pay for instruction as well as equipment and place to do our program. As I speak to you right now, we're working with St. Paul College to make this program a collegiate bearing program in addition to the work hours that's given that the construction industry so highly value. Also, this program, with this leverage from this committee, we can allow it to go into, put this work environment into St. Paul College as well. So this opportunity for grant that we have in front of you will also get us to leverage this resource with a lot of the charitable giving that we received up to this point, but also to focus on other foundation elements of our program, such as young men's well-being, their mental health, other addiction they may have that prevent them from employment, also to stabilize themselves in terms of housing, connecting with their families, and we feel all of these areas is our strongest interrupter into the flow into the criminal justice system. We have marked success, and the success that we measure on new offenses that lead into incarceration is at extremely low rate. So we do feel that the program we put in place, this holistic program, by surrounding with the service they need to stabilize their lives, also allow us to keep young men from being engaged in the criminal justice system. So the demonstrated positive and measurable results that we've gotten is here to be looked at, and that we've shown to the state of Minnesota there's a tremendous investment, return on investment when they invest in this program. So very quickly, I'm just honored to come back before you, say thank you for your support and investment. Open myself for questions if there's any.
Thank you. Any questions from members of the committee? Representative Mahoney?
Thank you, Mr. Chair, and I will say that this is a program that I've come to know in the last couple of years, and I really appreciate what they do. I don't want to get too deep into the weeds with this, but I know that you've put and this is the question for the testifier, I know you've put an emphasis on the construction trades. Many of the large construction employers or customers, and I'll probably get in trouble naming some of them, the oil refineries, the power plants, the big chemical plants there. I didn't get in any trouble. Have a security background check, which eliminates the someone coming onto their premises with a felony charge in their background. Have you, or do you plan on having conversations with those particular entities about how you could get around that piece in their security check? And I'll just leave it at that.
Mr. Chairman, Representative Mahoney, yes, a person's criminal history has been a barrier for a lot of employment industry. We're very fortunate. One of the reasons that Ujama Place is investing in the construction business is because of the aging workforce. As the baby boomers are sunsetting out, we're finding out that there's a dearth of people available to enter into this trade. So we have gotten a relationship with, like, the Carpenter Union, for example, that's willing to take guys with felony records. We also have found a great employment opportunity with residential carpentry, as well as some of the construction programs like Thor and Morton Construction. So those are agencies that actively engage and recruit people that have had some hiccups in their careers. And we have not, some of the ones that you mentioned at this point, but there's some that we like to explore. But our primary history right now has been with construction ones that we know that there's jobs. We've had a great success placing guys, like I say, into the carpentry business, as well as some of the construction building that's taking place.
Representative Mahoney.
Well, thank you, Mr. Chair, and just to the testifier, there's an awful lot of people that represent those three entities that I mentioned in the room. You might want to see if you could find them, tackle them, hold them down, and get an agreement.
Madam Chairman, Representative Mahoney.
Did you say Madam Chair?
No, Mr. Chair.
Okay. Yeah, no kidding. Mr. Sanders.
Ms. Mahoney, I would definitely follow with those contacts, sir. We would love to have more. Our organization will take advantage of all opportunities that would take a chance on the young men with barriers. I will say that a lot of people that's coming to our midst, not all have criminal records, but their interest in finding stable employment and gaining a foothold and being a positive citizen, we seem to work with. This program is not for everyone. There's a lot of people not willing to go through this intensive environment or situation that we use for PREP, because we don't refer anyone for housing employment unless they've engaged in our employment program. So that part of being continuous case management service seems to be something that landlords as well as employers are willing to take a risk on.
Thank you. And any other questions from members of the committee? And I think you point out an important problem with American society right now. We are far too quick to judge, and we are too slow to forgive. Yes. And I think we all can do our part to improve upon that. So thank you very much for your testimony.
Thank you, Mr. Chairman.
Megan Christensen and Terry Mattson. Then I have Margaret Anderson Kelleher and Steve Gottwalt on deck. Welcome to the committee. Please state your names for the record, and please proceed with your testimony.
My name is Megan Christensen. I'm with the Executive Director of Visit Grand Rapids, and my last name is spelled Christinson.
My name is Terry Matson. I'm the President and CEO of Visit St. Paul and the River Center.
So thank you so much, Chairman Garofalo and the committee, for letting us speak on behalf of the Major Events Funding Bill. I represent one of many Greater Minnesota small, medium, and large-size destination marketing organizations, are also known as convention visitor bureaus. We represent a diverse Minnesota destinations from Thousand Grand Lakes to Prairie Lands and everything in between. We are primarily rural with populations in size of a couple thousand to tens of thousands. We market and promote to lure visitors to our specific locations within Greater Minnesota. Our annual budgets range in tens of thousands to hundreds of thousands. Currently, major events happen in larger, more dense population communities in Greater Minnesota. The Major Event Funding Pilot Project would allow for all Greater Minnesota communities to help secure major events to their communities. Major events have the potential to draw thousands and bring increased economic impact through overnight lodging and spending by visitors while they are in town. I will give you 3 examples of events that we are looking to secure in the future for our community. Bass fishing tournaments have become very popular in the state, and it draws from all over the country. Bass fishing is the #1 segment in fishing across the nation, and this brings in tens of thousands of people, and the purse sizes of these events can be upwards of $100,000 or more. We have significant economic impact with overnight lodging, people dining out in our restaurants, and the additional tax revenue that is generated on behalf of that. Another event that we were able to secure is a brew fest. So we're trying to get as creative as we can to lure people out to Greater Minnesota, and this is one way of the trend of microbreweries. So we will have 30 corporate microbreweries sampling over 100 beers, live bands, and food trucks on site. We will be having other creative ideas like 5K runs, paddle races, so like stand-up paddle boards or kayak, And then we also are looking to entice the Grand Rapids and Itasca Mountain Bike Association to do a fat tire bike. So it'll be a cross-section, lure outdoor recreation because of our wonderful trails. This is something that a lot of greater Minnesota communities can lure to their community because of their trail development. We are looking at getting back the National Lumberjack and Lumberjill World Competition. The purse on this is $50,000, and it brings tens of thousands of people. We're looking at 500-plus room nights and 5,000 to 10,000 people in attendance. Other events that have been brought up are fat tire bike races, 5K races, snowshoe races, things that are out of the ordinary. So it would definitely having an opportunity for major event funding, helping have a little bit extra money to help seed the additional dollars that you have to leverage those dollars would be very beneficial. Thank you so much.
Well, I think we're going to have the committee take some further research on Brewfest. I think we'll have to look into that. So welcome to the committee, sir.
Thank you, Mr. Chair and members. Thank you very much for including the Tourism Events Pilot Project in your supplemental budget bill. I especially want to thank the chief author of the bill, Representative Baker, for his hard work and diligence. The proposal is a way to assist local, regional, and statewide communities in securing the funding for significant tourism-related events across the state. I'll be brief in just saying our goal is to increase the economic impact of visitors on local and state economies and increase visitor spending throughout Minnesota. This is a very, very good investment. Thank you for your time. Happy to answer any questions if you have them.
Thank you. Any questions for our testifiers? Thank you very much. I'm told that Ms. Kelleher is parking, so is Ethan Vogel here from AFSCME Council 5? You're not Ethan Vogel. No, I'm not. That's all right. Welcome to the committee, sir. Please state your name for the record and proceed with your testimony.
Thank you, Mr. Chairman. My name is Elliot Side. I'm the Executive Director of AFSCME Council 5, and we represent 40,000 state, local government, and nonprofit workers throughout the state. Mr. Chairman, we are testifying today to oppose the so-called hands-off child care repealer. Mr. Chairman and members, we believe the war on workers continues under this leadership. Just 2 weeks ago, there were 2 other attempts to restrict and undermine the voice of workers. Representative Drazkowski sought to eliminate dues checkoff and fair share with a bill that included the approval of state employee contracts, holding those fairly negotiated contracts hostage to language that eliminated state employees' right to bargain in the future. Then he replaced that section with an amendment to limit the political rights of state employees. Now today, Mr. Chairman, it's proposed to take away the rights of child care providers to collectively bargain and have the right to vote on that. Indeed, we recognize there was an election for union representation, which was rejected by a majority of those voting. The law was created to give those workers the right to vote. And while AFSCME Council 5 chooses not to exercise that right at this point in time, that right should continue to be held by the legislature. It's like today, I don't care to pick up a gun, but I still think the Second Amendment needs to be protected. We ought not get rid of the rights because just today, we don't feel like picking up a gun. The law will expire on June of 2017. This repealer is unnecessary and dangerous. Once again, we're finding, unfortunately, Republican leadership seeking to take away the rights of workers to collectively bargain for a better future. It shouldn't be a one-liner that throws away workers' rights, human rights, or civil rights. The description of this amendment is quite ironic, we find. The federal government recommends a reimbursement rate for child care assistance of 75%. In 2004, Minnesota was at 68% of the market reimbursement rate. By 2014, after 6 years of Governor Pawlenty and 2 more years of your majority in the House and Senate, those rates went to 30%. I guess that's the results of hands-off child care policies. If we're really interested in improving the lives of providers and eliminating the waiting list of 7,000 families waiting for CCAP, the neediest and poorest families in our state,
If we're really interested in ending disparities, then we would support the governor's recommendation for $28 million for child care providers and CCAP recipients. But instead, once again, the decision's made to attack the rights of workers to organize and bargain. The grandmothers and great-grandmothers of this female-dominated profession couldn't vote until 1920. And again, members of this committee seek to repeal women's right to vote on their own livelihoods and workplace rights just to put out another fundraising letter. After a decade-long battle, it's become clear who helps and who harms working families and our children. We want to thank Democratic leaders who affirm the child care providers' right to vote for a union. And we want to expose those legislators who cut the providers' pay and training while ignoring 7,000 families waiting for child care assistance. We ask you to vote this down. We think it's unfair, unnecessary, and once again an attack on the workers' rights, the civil rights, and the human rights of these child care providers. It's up to them to decide if they want to have a union or not. They've decided once, they can decide again. Thank you very much.
Thank you. Any questions from members of the committee? Representative Scott.
Really more just of a comment than a question. You know, I recently was able to attend an annual event from the Child Care Workers Association in Anoka County. And what I saw there was a lot of mostly women. I think there was maybe 2 instances where it was a husband and wife team that owned the business. These are small business owners, and they don't want to be unionized. Not one person in that room of probably, I don't know, 60, 70, 80 women and men, not one of them came up and said, yes, we support the union. They feel like their rights were tread upon when the legislature tried to scoop them in to be a government employee. So I see that they're here to testify on their own behalf, but I can't wait to vote for this, Representative Garofalo.
Any response, Mr. Stein?
Just, Mr. Chairman and Representative Scott, I was also at a meeting of about 40 child care providers outside of Alexandria where all of them wanted to have a union. But that's not the point. The ones who don't are the ones that do. The fact is they ought to have a right to vote on that issue. And that's all that this bill did. So I think that that's what we're arguing for, the rights of workers to vote about their own livelihoods and have some control over their own work lives. If they're independent providers, if they're traditionally employees in a workplace, the new economy, we're going to see more and more independent providers as corporations, as public sector, as everyone sheds their responsibility for workers in terms of their health care, in terms of their wages, in terms of their other conditions of employment. This new economy is creating more and more independent providers that need to have some kind of way to organize together in order to promote their economic rights. Thank you, Mr. Chairman.
Representative Mahoney?
Thank you, Mr. Chair. Mr. Side said it just as well as I could. I had a meeting in my particular district, and there was 5 or 6 providers in my small district of 40,000 people that want to organize and want to have a voice at the Capitol and want to actually get a decent wage for the work that they do. You know, I've been a union member for 30 years. It's the most democratic organization ever. I know where my business manager lives. I know what kind of car he drives, and I know his personal cell phone number. And he hears from me rather regularly. And I have a chance to vote on any particular issue that comes in front of it. These people have a right to vote if they want to be in or they don't want to be in. So I certainly hope when this amendment comes up that we pull that anti-worker language out of this particular bill. And if in the next year they choose to have a vote, I would certainly hope the people who do not want to be in a local union voice their opinions about it. And those, because I know those that do want to be in a union will voice their opinion about it. So, Mr. Chair and Representative Scott, I know there's 2 sides to every coin. We all get to have, I don't know why we want to take someone's right to vote on something away.
Any other questions or comments from members of the committee? Representative Simons.
Thank you, Mr. Chair. Just a question for you, and I've not been here every single day, but did we hear this as a bill in committee along the way somewhere?
Representative Simonson, no, we did not.
Mr. Chair, do you or staff perhaps have a list of bills or provisions, I should say, in your omnibus bill that were not heard in committee, just so we could get that at some point, maybe?
Well, Representative Simonson, I think that list would be short, but we can certainly request staff to put that together of those provisions. This is, just to be clear, this is the hearing on those bills, and many times, as you know, provisions are interlocked with one another. So hearing one section of a comprehensive approach doesn't make sense. We can definitely have nonpartisan staff put that together for the bills we did. If there were, I don't think there were many, but the bills in this bill that were not given a hearing before today.
Thank you, Mr.
Representative
Chair.
Simonson.
And Mr. Chair, thank you. That would be helpful to have. And I think, just as a point about this particular provision, I mean, the language does expire in 2017, and I personally see this as a, it's really nothing more than a poke in the eye, I think. But you've got some really good policy provisions in this omnibus bill on a couple of pages. And I would, and then there's some that's maybe not quite so good. But this particular one, I really don't see any reason why we would need to take it up. So I would agree with Representative Mahoney that when we do take up that amendment, it'd be a good thing for folks to vote on.
Thank you. Any other questions or comments from members of the committee? Thank you for your testimony, sir. Oh, did I miss one? Thank you for your testimony, sir.
Thank you, Mr. Chairman.
So is Margaret Anderson Kelleher here? Margaret Anderson Kelleher and Steve Gottwalt's on deck. And you can both come down now, so that way we're... Oh, it's that Steve Gottwalt? You go to the end of the line, sir.
We do have them in the short
Welcome to the committee. Please state your name for the
Thank you,
record.
Mr. Chair and committee members. I want to provide brief testimony on the provision on broadband and broadband funding today. And thank you, Chair Garofalo and committee members. I want to also thank Representative Baker, and I also want to thank Representative Johnson for his steadfast leadership on this issue. Today, I am here in my capacity as the chair of the Governor's Broadband Task Force. I want to thank the committee members for considering and having in the bill the funding on broadband, and to state that there are 3 areas to focus on today. First of all is the funding of the grant program. The task force recommended to Governor Dayton and to the legislature a funding level of $200 million this year. The governor, as you know, recommended $100 million, and we are happy to see that the House is making a significant investment in broadband this year, especially in the base recommendation towards this program, this very important program, and has made a commitment in the base level funding. However, I would like to point out that I do believe, and I think the task force members would want me to point out, that the funding goes well beyond the level that's provided in the House. And it's estimated that the need in greater Minnesota, especially in terms of those Minnesotans who are not connected, ranges at a sort of lower level connection of $900 million to connect Minnesotans to up to $3.2 billion at a fiber level connection to connect all Minnesotans with broadband. In the last 2 years, you have been able to provide through the legislature about $30 million of broadband funding. That's leveraged $41 million in private funding. And so we do know that for every dollar that's provided in this program to connect Minnesotans, especially in rural areas, it will leverage more than $1 of private investment. This will help meet the demand for Minnesotans that's estimated to be at least 178,000 households who are not connected to high-speed broadband, at least at a 10 megabits by 5 megabit connection, to be able to connect with $100 million. We at the task force support having a higher level connection to be able to do necessary tasks like higher education, being able to connect to do homework for K-12 education, healthcare, and I know that my former colleague, Representative Gottwald, is going to talk about that. We also see the need for updating the speed goals for the state of Minnesota to 25 and 3, as well as having a stretch goal by 2026 of 100 megabits per second upload, and having all Minnesotans get that connection of 20 megabits download speed, upload speed. So we just want to reiterate that it's important to also think about regulatory updates to Minnesota's laws, and I know, Mr. Chairman, that you are very interested in this as well, in both telecom and VoIP, and I believe that you may be seeing some things on that later today. I will be watching for that as well. It's important to keep these things moving forward for the importance of moving Minnesota forward as well. And the broadband task force, I think the important thing is to look to the recommendations of the task force, but I know your major focus today will be on both the finance side of this and the speed side of this. So thank you for your time today and your attention to the issue, and particularly Representative Baker's leadership on the issue.
Thank you. Questions from members of the committee? Representative Baker and then Mahoney.
Thank you, Mr. Chair, and Ms. Kelleher, thank you for your work on this. And again, I want to apologize for being a little late today. I was in Wilmer with the Lieutenant Governor. We were talking about broadband, and it was actually announced today from CenturyLink, and I want to give them kudos for announcing today $1 million from the CAF2 funding going into the Wilmer area in Candiota County, which has not happened to us before. So we're pretty excited about that. More than 400 homes and businesses will be hooked up with new service that they haven't had before. So I just wanted to say that I don't think there's ever seems like there is enough to do this, but it is happening out there even without state funding as fast as we want it to do. But I just wanted to say that that was a great announcement today in Candiota County. And again, because of a lot of folks' work on this, good things are happening out there. So thank you again.
Representative Mahoney and then Wagenius.
Thank you, Mr. Chair. And I'm going to tell a little bit of a story here. I remember a legislator that tried to reduce the a request by a Speaker of the House by about, well, it got the request that Speaker had down to about 15% of what they wanted, and that legislator got dressed down rather forcefully. I won't mention any real names here. So, Madam Kelleher, former Speaker Kelleher, would you say that a 15% down payment on this year's or a 1.6% down payment on the $900 million might get a dressing down from a speaker if somebody tried to pass that off as a good idea or a significant investment?
Let's see how good the testifier is at not answering your question. Representative Ms. Kelleher.
Well, Mr. Chair and Representative Mahoney, so I think
I've been waiting for this moment for you.
I like to go fishing with you, but I think I'll be careful not to take that bait. You know, what I do think the important part here is, and I understand the pressures on each of the two bodies are different, and at the end of this experience, which will come around the middle of May, is what comes out at the end. And so I do believe that people are acting in good faith and goodwill to get to conference committee. And so all I can do is keep telling you that the Governor's Broadband Task Force, which is made up of a wide range of stakeholders, including private providers, advocates for public systems, foundations, rural advocates, have said there is market failure out there in rural areas where even with federal money, as Representative Baker has pointed out, there's going to be places that Minnesotans aren't going to get connected to high-speed broadband. And that's the place that by creating this fund, a role that the state is playing and has played. And so there is a need, and you can play a role again this year with being able to leverage these critical state dollars with private dollars and be able to do something very good for the people of Minnesota.
Representative Mahoney.
Well, Ms. Kelleher, and to the chair, to start this one of the roles of a chair is to educate the committee on the needs and the desires and the ability to pass legislation and/or fund particular things. This state has a $900 million budget surplus. And, Mr. Chair, you have not educated this committee or this legislator, and I've been here for each and every one of these committee hearings, as to why we would barely scratch the surface. A 1.6% investment in bringing broadband to greater Minnesota. I don't know how the members of your committee can in good conscience vote for something like this. Mr. Chair, when you start this far apart, heading towards a conference committee, we've seen this act before, and I certainly expect to see it again. But again, Mr. Chair, there's been no understanding of why we should start at such a low dollar figure when we have $900 million. We could actually make a dent in greater Minnesota's funding and broadband. I have missed committee. I missed a special session because broadband was not available where I was. I get back and I got 10 miles closer back towards home, and all of a sudden my phone lit up with all the emails that did not come to me. And I fortunately missed the special session, but that's another story. But again, Mr. Chair, this is your job to educate us as to why, and you have not done that.
Representative Wagenius and then Johnson.
Thank you, Mr. Chair. You had mentioned something about kids in school. Do we have numbers of students who are not served? And I guess I'm looking, I suppose it's for all K-12, but I'm particularly interested in high school and junior high, who don't have good access. I know my grandchildren in high school, all of their math and science, physics or chemistry is all on computer. I mean, they talk to their teachers by computer, and their parents talk to their teachers by computer. Do we have numbers here?
So, Mr. Chair and Representative Wagenius, we can provide for you a report that was done this year in Minnesota by a national group called the Education Superhighway, and they have done a study in Minnesota. There's good news and bad news. The good news is that, generally speaking, our schools are pretty well connected in Minnesota and have high-speed connections. We've done a good job having a connected system at our schools and largely at our hospitals for the most part. Our long-term care facilities, there's some patchy spots there. And then I would say the issue for students is exactly what you just identified. And that is when students go away from school on the school bus or drive away from school at night, that's when the problem starts. And so this is exactly why we're talking about this issue. Because when the teacher says, students, I need you to go home and access the online textbook, or students, I need you to do your homework and watch this set of videos online at home, or do whatever they need to do, we have many students in the state who have trouble doing that and completing their homework. So what do? They either have to stay at school, and the school does need to close at some point. They need to go to a library building. That's why we're advocates for more library funding in what we say in the broadband report. And the third thing that we see happening is we do see students who have to drive, and they sit outside the McDonald's or the Hardee's or wherever they can find Wi-Fi access in their town, and they use it. And that's where we see librarians tell us, Mr. Chair, all the time, we don't turn off the Wi-Fi at night in the library, because that is how people do their homework or apply for a job in our town.
Representative Wagenius.
But I know high school students and junior high school students, they're doing their homework at 10 o'clock at night or 11 o'clock at night or
Exactly.
midnight. So, and they should be at home doing their homework. The amount, I mean, we're talking 3, 4, 5 hours of homework in some of these, if you're doing math. And we want kids to do math. If they're doing, and physics or chemistry, it's all online. So it would be helpful, I think, if we had the number of students that were not being served, because they're now at a huge disadvantage, I think, to the kids that are in Minneapolis, for example.
Mr. Chair and Representative Wagenius, we'll provide that to you. And then when you think about their parents who might be trying to access higher education, MnSCU's classes, 36% of the MnSCU classes are provided online now. And if you are the working parent who wants to try to access that online and need to do that at 11 o'clock or midnight or 1 o'clock in the morning, then you really are at a disadvantage.
Representative Johnson.
Thank you, Mr. Chair. Madam Speaker, did the Broadband Task Force have an opportunity to vet the right of first refusal policy that's been proposed? I see some obvious problems with it, but I'm curious whether you've had a chance to look at it.
Ms. Kelleher.
So, Mr. Chair and Representative Johnson, the task force itself did not vet the right of first refusal. Mr. Chair, Representative Johnson, I do think that if you all work together, there are probably some better options working with the Office of Broadband on the issue.
Representative Johnson. Any other questions or comments for the former speaker? Good to see you as always.
Thank you.
Welcome to the committee, sir. Please state your name for the record. Mr. Busselman, you are on deck. You can come on down too.
Mr. Chair, committee members, my name is Steve Gottwald. I'm the Executive Director of the Minnesota Rural Health Association. Appreciate the opportunity to testify. I'll keep it brief. As you might imagine, my testimony is focused on the appropriation contained in Article 1 and the provisions contained in Articles 11 and 12 of this bill. We appreciate Representative Baker's leadership in this area, and high-speed broadband is important for telemedicine. As we experience workforce shortages in rural health care, one of the ways that we are going to be able to solve that and deliver quality, cost-effective health care to rural Minnesotans is by extending expert resources through telemedicine and through other technologies that allow us to monitor and respond to people where they live. The Rural Health Association is a private nonprofit. We represent dozens of hospitals, clinics, nursing homes, healthcare providers, medical educators, and health consumer advocates from across our state. Our mission is to strengthen health and healthcare in greater Minnesota through leadership, education, collaboration, and advocacy. We've endorsed our own broadband vision statement that basically says all Minnesotans will have access to affordable broadband networks that enable access to broadband-dependent health and healthcare services. And in achieving this vision, we recognize that we need both public and private sectors. We're not picking sides here. I think as Ms. Anderson-Kelleher just stated a moment ago, there is room and need for both. Again, we applaud Representative Baker's leadership on the issue and believe that both are important. The governor's Task Force on Broadband has recommended modernizing the state's telecom laws. That, again, is contained in Articles 11 and 12 as an important part of this effort to expand broadband access. For those who think a new technology is on the horizon, we can't wait. In case you've looked at the demographics in Minnesota, and particularly in rural areas, we are aging into our top healthcare utilization years at a lightning pace. We need high-speed broadband to serve underserved areas. With last year's passage of the Minnesota Telemedicine Act, we now have state policy encouraging and reimbursing for extension of healthcare resources into rural communities using telemedicine, but only where there's sufficient broadband for such cost-effective medical services. Again, it's part of the solution to delivering quality, cost-effective health care to rural residents. We again thank Representative Baker for his leadership in recognizing the urgent need of real progress toward expanding broadband access to underserved areas of Minnesota, and we urge this committee to support those provisions in this bill. And with that, Mr. Chair, I'll stand for questions.
Representative Johnson.
Thank you, Mr. Chair. Good afternoon, Mr. Gottwald. The question I have on wireless versus wireline. My understanding is wireless might have some difficulty providing the capacity to provide the sort of telemedicine services that are so essential. Can you help me understand that a little bit better? Is that a fair comment?
Mr. Gottwald.
Mr. Chair and Representative Johnson, that I believe is the case in many instances. I'm not the technological expert, but I do understand that in many cases we need 20 megabits to do some of the telemedicine functions. And it's part of the reason that we need a further investment in broadband access so that we have sufficient capacity to do those higher-end telemedicine functions.
Representative Johnson. Any other questions from the committee? As always, good to see you. Welcome to the committee, sir. Please state your name for the record. And Mr. Wirtz, you are on deck. Next is Tony Mendoza, then Jennifer Parrish, and Julie Seidel. Welcome to the committee.
Mr. Chairman, for your record, Doug Busselman. I am the Director of Public Policy for Minnesota Farm Bureau. Farm Bureau supports the expansion of telecommunications services with greater access for all persons in rural areas at affordable prices. This is especially important for improvements for increased high-speed internet access. We greatly appreciate those who have given attention to this important issue. Along with necessary financial resources and priority attention to accomplish the objectives of delivering on improved broadband access throughout rural Minnesota, we also need to consider regulatory certainty and modernization of how delivery is approached. Due attention is required to the transition to Internet protocol networks which link the various tools like cell phones, computers, tablets, and other devices that have become important components in today's farming business and family activities. Again, thank you for the attention being given to expansion of access for rural Minnesota. We appreciate your efforts and look forward to the progress taking shape. Thank you.
Any questions or comments from the committee? Thank you. Welcome to the committee. Please state your name for the record. And again, Mr. Mendoza is on deck, then Jennifer Parrish, then Julie Seidel.
Thank you, Mr. Chair, members of the committee. I'm Paul Wirtz. I'm the state president for AT&T Minnesota. It's my pleasure to speak on behalf of the VoIP provisions of this bill, VoIP IP preemption. Representative Mahoney, at the risk of interjecting Wisconsin into this dialogue, let me just say that this bill is not groundbreaking. This bill has been passed in 34 states, and I bring out Wisconsin because it's in fact probably the one policy provision in telecommunications where you could get Scott Walker and Jerry Brown to agree. This bill is passed, as I said, in 34 states. Literally half of the governors that signed this were Democratic governors and half were Republican. This is about really investing in the future and really an interstate service that will help provide additional technologies and advancements for businesses and residents over broadband. 2/3 of Americans have chosen wireless or internet-based services as alternatives to traditional phone service, and another 450,000 customers join them every month. In fact, your phones right here in the State Office building and over at the Senate and the Capitol are VoIP phones. According to the FCC's report at the end of 2013, there were more than 852,000 interconnected VoIP subscribers lines in Minnesota from 116 providers. Of these, 465,000 are residential lines and 387,000 are business lines. The ILEC served about 2,000 of those lines, and competitors doing the remainder. Nationally, there are more than 48 million VoIP subscriber lines, representing about 35% of all residential and business retail lines. It's appropriate this language should be part of the broadband package. VoIP IP technology is a broadband service, and this bill will provide certainty for investors and innovators in Minnesota and the app economy, and they will not be hindered by the legacy telephone regulations that are part of the 20th century telecommunications structure. IP communications promotes telework, allowing people to work seamlessly from home, as if they were in the office. IP's ability to converge voice, video, and data into one application makes available new accessibility options for tens of millions of disabled Americans. I'd like to point out that the language has the support of my colleague, Margaret Anderson Keller, in her capacity of the Minnesota High Tech Association. Let me just illustrate, as a member of the Governor's Broadband Task Force, the former speaker pointed out that this is one of the support for telecom modernization is one of the policy recommendations for the task force. And I quote, this is from page 34 of the report. States across the country have passed legislation to modernize their telecom laws and keep communications free from outdated rules not designed for today's IP world. Minnesota should consider similar legislation designed to help spur innovation, attract high-tech investment, develop rural broadband, and address consumer protections that showcase the state as a place to do business. Furthermore, the Pell Center study in 2015 in September highlighted that one of the platforms of good state broadband policy, telecom reform legislation, is a major component to the elements of good broadband policy. To serve the public good, states should consider telecom modernization bills ensuring that residents have access to affordable, reliable communication service, including broadband. Now, the FCC, since 2005, has issued more than 20 rulings with respect to consumer protection, 911, and other public safety factors. That's why this service is really best left to the FCC and is interstate in nature. But this legislation, this provision, does contain something that is specific and unique to Minnesota alone. I believe you'll be entertaining an amendment shortly that was part of the original VoIP legislation with respect to a filing requirement by all VoIP providers for 911 to the Public Utilities Commission. This is something that no other VoIP legislation in the country requires of VoIP providers, in addition to the requirement that all providers will pay into the TAP, TAM, and 911 funds. But that filing requirement is unique to this state, and it's something that we worked out with the Department of Public Safety, and we're happy to do that. With that, Mr. Chairman, I'd entertain any questions.
Any questions from the committee? Representative Johnson.
Thank you, Mr. Chair. Now, would a VoIP provider, a fixed VoIP provider, would they have any obligation under this bill to serve in any remote or low-cost area in the state? Would they be obliged to serve someone way out in the sticks or an area that was more expensive? And is it true that they could increase their rate as they saw fit without any oversight from the regulatory agencies? Is that also accurate? And then finally, would all the consumer protections of legacy telephone industry that's been in effect for well over a century no longer be in effect?
Mr. Wertz.
Mr. Chairman, Representative Johnson, these requirements do not apply to VoIP providers today. First of all, you have to have a broadband connection to actually get VoIP. So what we're basically saying is in this legislation that the oversight that the PUC has, the state has today, and it is limited in nature, that is really a go no further than what the ability of the state is today to regulate VoIP service. Those are, what you're describing are really legacy landline-based telecommunication requirements. I think the greatest analogy is the wireless industry. We don't have those type of regulations in the wireless industry, and yet you look at the innovation that's taken place over the last 10 years. We've gone from really no G to on the steps of 5G, bringing gigabit service, with largely federal protections, customer protections, public safety, with some limited state oversight in those regards. Not obligation to serve, or not in a very hyper-competitive, price-competitive environment. I think that's the model that we would aspire to with this legislation.
Representative Johnson.
Thank you, Mr. Chair. Well, didn't in fact our PUC in Minnesota make a landmark decision this past summer in which they determined that VoIP providers are under their regulatory authority? And isn't it true that there is a case in U.S. District Court now between Charter and the state of Minnesota, the PUC, to address this question? It seems to me rather premature to bring forth this legislation that is currently under a judicial review.
Mr. Wertz.
Mr. Chairman, Representative Johnson, I'd like to defer to my colleague, Mr. Mendoza. I believe he's been involved intimately in that case. With your permission.
First of all, is there any other questions for the testifier? Thank you very much for your testimony. Welcome to the committee, Mr. Mendoza. Please state your name for the record and proceed.
Good afternoon, Chair Garofalo and representatives. I'm Tony Mendoza, counsel of the Minnesota Cable Communications Association. Thank you for the opportunity to address Article 11 of this bill, VoIP regulatory reform. Representative Johnson, I do intend to get to your question. I just have a couple of preliminary remarks that I'd like to make. Many companies provide phone service using technology similar to what's used to deliver email, texting, and other web applications. It's called VoIP, or Voice over Internet Protocol, and it runs like many other applications over a broadband connection. And getting to Representative Johnson's question, I'd like to provide a little context. In 2003, the Minnesota Public Utilities Commission attempted to assert jurisdiction over VoIP and was preempted by the same federal court that's hearing the case that he's referring to right now. That jurisdiction was also preempted by the FCC. Since then, the VoIP market has exploded in Minnesota. As Mr. Wertz alluded to, there are now roughly 120 VoIP providers operating in Minnesota. That's just VoIP providers. That doesn't count incumbent Lex. There's more than 65 of them in the state of Minnesota, CenturyLink, Frontier, and Wireless. Recently, Representative Johnson is correct. The PUC has again attempted to regulate VoIP despite being told once that it cannot. And that is what this case is about. The PUC has attempted to make or reassert jurisdiction over VoIP providers over a certain group of VoIP providers based on a technological distinction in the way that they deliver the service. And we are challenging that in federal court because we believe that the FCC has already, and the same federal district court that's hearing that case right now, has already preempted that authority once. This bill would bring regulatory certainty for VoIP providers in Minnesota rather than continuing this sort of whipsaw effect of on-again, off-again regulation. And despite a lot of misinformation about this bill, consumers will remain protected. As Mr. Wertz again alluded to, there have been 20 FCC orders, unique orders, that have applied consumer protections to VoIP services. In the 36 states that have adopted VoIP reform, and this is again to Mr. Representative Johnson's question, no one is losing landlines. In fact, there was a study done by the research arm of the National Regulatory Institute, that's the research arm of the National Association of Regulatory Utility Commissioners, that showed that in states that have modernized their telecommunications statutes, there have not been price increases, and people have not lost their landlines. In fact, with the expansion of broadband in rural areas, which is the subject of many other parts of this bill, that will enable more people to have access to landlines. It'll just be over a broadband connection instead of fewer people having that access. VoIP reform provides incentive for broadband investment. If you don't believe this, look no further than where Google is investing in fiber to the home. In 14 of the 17 states where Google is deploying fiber to the home, those are states that have enacted similar legislation to what's contained in Article 11 with VoIP reform. In respect to 911, the Telephone Assistance Program, and the Telecommunications Access Minnesota program, this bill strengthens these programs by ensuring that all VoIP providers, and not just some, as is the case today, help fund those programs. The goal here is a national uniform policy for telecommunications and voice. The FCC said that when it preempted the PUC's first attempt to regulate VoIP, and I quote, "We cannot permit more than 50 different jurisdictions to impose traditional common carrier economic regulations, such as Minnesota's, on Vonage," that was the company that was involved in the original case, "and still meet our responsibility to realize Congress's objective." The Minnesota Cable Communications Association strongly supports VoIP reform in Article 11. We applaud Representative Sanders and the other authors of this bill for their efforts, and I thank you, and I'm happy to answer any questions.
Questions from members of the committee? Representative Johnson.
Thank you, Mr. Chair. Just a comment, I guess. That is, VoIP telephone service is essentially indistinguishable from traditional phone service, and we should be regulating that service and not make huge changes based on the new technology of IP being used. So that's just a comment, Mr. Chair. Service should remain regulated as is.
Any closing comments from the testifiers? Thank you very much for your testimony.
Thank
Next, Jennifer Parrish and Julie Seidel. And then we're going to, do we have the commissioners here? 1, 2? Okay. So we'll take the commissioners up after these two. Welcome to the committee. Please state your names for the record and proceed with your testimony.
Good afternoon, Mr. Chairman, members of the committee. My name is Jennifer Parrish. I'm a licensed family child care provider from Rochester and a member of the Coalition of Union-Free Providers, a voluntary organization of child care providers across Minnesota who stand together advocating for our independence and the right to remain union-free. I'm here today to urge you to support the Hands-Off Child Care Act repealing the 2013 law authorizing collective bargaining for providers who own and operate small child care businesses. As I'm sure you're aware, small businesses do not have collective bargaining rights because they do not have an employer to collectively bargain with. As with any other small business, we child care providers set our own rates and hours of operation. We create our own working conditions and choose which clients we work with. Even after the Family Child Care Representation Act passed in 2013, we still do not have an employer to bargain with. We still have sole control over our programs and are still not employees of the state or anyone else. We take great pride in owning and operating small businesses. We did not ask for, nor did we want, collective bargaining rights. As some of you may remember, we vehemently opposed the idea, closing our businesses to protest and testify at the Capitol. It was labor unions that wanted and fought for those bargaining rights for child care providers. And in 2013, their influence was unfortunately stronger than ours. We raised many concerns as this was being debated, including the legality and constitutionality of this law, the potential danger of having union organizers who hadn't completed background studies through the Department of Human Services coming unannounced to our homes while we were busy caring for children. And we raised a lot of concerns about the vote itself, including lack of fairness, transparency, and voter suppression. In spite of our concerns, most of which came to fruition, by the way, we were told that child care providers should get to vote and choose for ourselves whether or not we wanted to unionize, that this was the American way. On March 1st, even though more than 2/3 of Minnesota's child care providers were excluded from casting a ballot, and every effort was made to give AFSCME an advantage, child care providers overwhelmingly voted against unionization, 392 to 1,014. We chose to remain union-free, and today we're asking you to respect our choice. After this vote, there is no reason not to repeal this law. Child care providers have been saying no for 11 years now. It's time to respect our decision. AFSCME has publicly stated that they do not plan to file for another election next year, and if they were being honest about that, they would have no opposition to repealing the law that would allow them to petition for another election next year. The lawmakers who supported this in 2013 simply because they wanted us to vote and choose for ourselves should have no opposition either, now that we've voted and made our choice. There shouldn't be concern about stripping child care providers of our bargaining rights when we didn't want them to begin with. In addition, the law never intended for these rights to be permanent. There's a sunset provision, and we're simply asking that the law be repealed a year earlier than planned so that we aren't faced with another costly and time-consuming election. Finally, we should not be subjected to another year of organizers coming to our homes during child care hours, unannounced, when we're busy caring for children. I cannot emphasize enough how intimidating and frightening these visits are for many of us. When they first came to my home, the organizer walked in without knocking and didn't identify who he was or who he was working for. He did not take no for an answer, arguing with me in front of the children. So many childcare providers across Minnesota have shared similar experiences, including during this latest round of organizing where at least 2 childcare providers had to call the police last November when an organizer allegedly claimed to be an agent of the USDA food program sponsor. When the officer suggested to this AFSCME organizer that it may be a good idea to wear his identification, something that we were assured organizers would do, he told the officer that his employer instructed him not to. Repealing this bill would help protect child care providers from incidents like this in the future. Mr. Chairman, members of the committee, I urge you that when the time comes to vote on this amendment, to please respect the choice of child care providers, respect our right to remain independent, and please vote in support of this amendment. Thank you.
Any questions from the committee? Welcome to the committee. Please state your name for the record.
Mr. Chairman, members of the committee, my name is Julie Seidel, and I am the Membership Director for the Minnesota Association of Child Care Professionals, MACCP. MACCP's mission is to strengthen the family child care profession by advocating for policy improvements, offering additional support and services to providers, and by promoting family child care as an exceptional option for quality care and early childhood education. MACCP supports the repeal of the Family Child Care Representation Act. While I could list the many reasons why, our position is a reflection of members' desires to remain independent. They unanimously decided we take a position opposing unionization rather than a neutral stance. They wanted their association to defend their right to continue to choose whom, if anyone, represents them and speaks on their behalf. The main reason I am testifying today, though, is in response to comments made by a Minnesota legislator last Friday when this repeal was being discussed in a different committee, suggesting that our associations are ineffective in part because we haven't been successful in getting a hearing to raise CCAP's rates this session. That may be a union would be better for us. MACCP would like to address this just in case other lawmakers have any similar misconceptions. Over the last decade, providers working through both local and state child care associations have written countless pieces of legislation, including bills to cap licensing fees, increase options for training, including expanded online options, eliminate redundant background checks for our substitutes, eliminate unnecessary paperwork, and ease barriers for providers closing their businesses short term. In addition, associations have played a primary role in stopping or minimizing the harmful impact of numerous pieces of legislation that would have been devastating consequences for family child care or the children and families that we serve. Associations attend stakeholder meetings and meet with state agencies and lawmakers both during and after legislative sessions. This year, MACCP, with the help of lawmakers, have introduced or supported multiple pieces of legislation. And for every bill we have requested a hearing for, we have received one. The reason we haven't received a hearing on a bill to raise CCAP rates is because we have not asked for one. In fact, we requested no changes be made this session because the child care assistant program is broken. Rather than invest millions of dollars in a broken program, we're asking for more. We're asking for the formation of a task force to thoroughly examine the program and make the necessary changes so it can work better and more efficiently for both parents and providers. Once long-term solutions have been implemented, we will support the appropriate amount of funding to eliminate waiting lists and improve payment policies and procedures so low-income families have equal access to quality care, something the current system does not afford them. If effectiveness were gauged by whether or not an organization has been successful getting a hearing to raise CCAP rates, it's worth noting the union has not been successful receiving one either, nor have they testified in support of proposals that would make improvements for family child care this session. The impact associations, including MACCP, have had and continue to have is profound and should never be minimized. Associations offer an opportunity to join together for as little as $25 per year to work in a collective manner to advocate for positive changes, all on a voluntary basis. It's especially important to recognize their contributions because nearly all are run by child care providers like me who volunteer our time to improve our profession. I am here today to urge you to not to marginalize or belittle providers or our associations for the benefits of a union or anyone else. Repeal this bill that has created such an adversarial relationship between the legislature and providers so we can work together for the benefit of Minnesota's children. Thank you.
Thank you. Are there any questions or comments from members of the committee?
Thank you.
Thank you.
All right, so we have, let's see, Commissioner Sieben, Commissioner Rothman, Commissioner Tinkerfell, and Assistant Commissioner Thornton. Those are the four I have. Is that correct? All right. So Commissioner Sieben, we'll start with you. Commissioner Rothman, you can come up and sit next to her if you want, so that we. Where do you go? Welcome to the committee. Please state your name for the record and proceed with your testimony.
Thank you, Mr. Chair, members. I'm Katie Clark-Sieben, the Commissioner of the Department of Employment and Economic Development.
Twitter. Sorry.
Thank you for allowing me to join you today. I want to start by saying thank you to Chair Garofalo and to the committee for the commitments you've made in this bill to DEED's Youth Workforce Development Competitive Grant Program, known as Youth at Work. As you know, workforce development is absolutely essential to meeting the needs of businesses throughout Minnesota, and that starts with our youngest workers. Studies also show that early exposure to work experience is one of the best indicators of future success. This funding will allow us to continue providing our at-risk youth with the training and career exploration opportunities they need to get ahead. We also appreciate the committee's investment in DEED's redevelopment grant program. The redevelopment grant program assists local communities with redevelopment projects by filling the financial gap that often prevents recycling land into more productive uses. Given the prohibitive cost of redeveloping dilapidated or underused properties, DEED has seen tremendous demand for these resources from communities all over Minnesota. Because the redevelopment program did not receive an appropriation in the 2015 biennial budget, we have now completely run out of resources. We're grateful the committee has committed to addressing this critical need now. Finally, as you might have expected, I'd like to discuss broadband. First, I'd like to thank Chair Garofalo and the committee for providing new funding for broadband development. Robust state funding for our border-to-border broadband grant program is the best way that we can ensure every Minnesotan has access to quality, high-speed broadband service. While we're grateful to have federal CAF II resources that are starting to flow into Minnesota, we also know these funds will leave many areas behind and will leave others still with internet that doesn't meet Minnesota's broadband speed standards. The funding in this bill will provide resources we desperately need to promote economic competitiveness and equity in employment, healthcare, and education across Minnesota. We are disappointed, however, that the funding amount is not closer to Governor Dayton's $100 million proposal or the Senate's $85 million recommendation. I know the committee may be considering an amendment that would remove the current $5 million per project funding cap, which would make this funding level even more concerning. I also wanted to quickly note a few points on the broadband policy provision in this bill, which I know you'll be discussing in greater detail today. First, DEED opposes the incumbent right of first refusal provisions as currently drafted. These changes, which would require border-to-border broadband development grant program applicants to submit their proposals to incumbent carriers, would be problematic for our applicants who do not wish to share their proprietary business data. Applicants may view this requirement as so detrimental that the application process would not be worth their investment. DEED shares the committee's goal of ensuring that state dollars are not duplicative of federally funded CAF II projects. Given the existing challenge process that provides incumbents the opportunity to weigh in on grant proposals, however, we believe this language is not necessary to achieve that goal. On a more positive note, I know you'll be considering whether to include the governor's task force on broadband 2022 and 2026 speed goals in this bill, and I would strongly encourage members to support that change. These goals serve as the policy backbone of the border-to-border broadband development grant program, and updating them is essential to advance Minnesota's leadership position among other states and countries. We do, however, have some serious concerns about the significant cuts to our major economic development programs included in this bill. The Minnesota Investment Fund and the Job Creation Fund are DEED's bread and butter economic development programs, and the state's bread and butter economic development programs. When site location attributes and other local assets are similar, economic development incentives play a key role in influencing a business's final decision on where to locate or expand. MIF and the Job Creation Fund funding allow DEED to put offers on the table to compete with other states and ensure Minnesota is as competitive as possible for projects. While these programs have a similar focus, these two programs have unique advantages. MIF loans are available upfront and can be used to offset capital expenditures, which can be difficult for companies to finance on their own, particularly in rural areas where conventional financing can be harder to come by. As a grant program, the Job Creation Fund provides a more streamlined option for companies once they've met the job creation criteria and capital investment commitments they've made to our state. It is a pay-for-performance program. We don't operate these programs because companies like them. We fund them because of the enormous return on investment they generate for our state. DEED estimates that the 70% cut this bill makes to the Minnesota Job Creation Fund in state fiscal year 2017 would mean that approximately $170 million in lost leveraged investment, 1,100 fewer jobs, and more than $220 million in lost wages. The proposed $80 million cut to the Minnesota Investment Fund would result in a loss of another $276 million in leveraged investment and 1,400 fewer new or retained jobs in Minnesota. Again, I want to emphasize these tremendous losses are only in the next fiscal year. With this bill's $10 million cut to Job Creation Fund funding and $20 million cut to the Minnesota Investment Fund base funding in the next biennium, DEED projects that Minnesota would lose out on $660 million in private investment, 3,600 jobs, and hundreds of millions of dollars more in wages. To save you the trouble of doing the math, these cuts total up to more than $1.1 billion in lost leverage dollars and 6,000 lost jobs. It's important to note that these cuts will also disproportionately harm greater Minnesota, where the majority of our economic development projects are located. DEED is also disappointed that this bill would result in significant cuts to Minnesota's dislocated worker program. As members know, dislocated worker program funding levels are determined by taking the Workforce Development Fund revenues and subtracting all of the appropriations that the legislature makes from the fund. So in effect, this bill's $4 million from the Workforce Development Fund in state fiscal year 2017 would amount to a $4 million cut to the dislocated worker program. DEED has long recommended that at least $30 million per year remain in the Workforce Development Fund after all appropriations are made, and even when the economy is good, to be able to serve Minnesotans who are laid off through no fault of their own. As we've seen over the last year with the avian flu crisis, downsizing at Target, massive layoffs on the Iron Range, we experience major employment churn even when our overall unemployment rate is low. These large layoffs affected 4,214 workers in state fiscal year 2015. While they don't make the news often, small layoffs are also a serious issue. As of February 2016, DEED was serving an additional 5,898 workers in this category. Given the tremendous demands these layoffs put on the dislocated worker program, DEED expects to fully exhaust all remaining Workforce Development Fund funding available this biennium. This means that laid-off workers are already likely to be put on waiting lists before the end of next fiscal year. An additional $4 million in Workforce Development Fund spending on the heels of a record level of Workforce Development Fund appropriations in the current biennial budget would leave DEED with dangerously inadequate resources to serve additional laid-off workers. So to put it in real terms, this $4 million in dislocated worker program cuts would mean at least 1,600 fewer laid-off workers would receive the services they need to get back on their feet. Individuals in greater Minnesota would be particularly affected since layoffs, such as those on the Iron Range, are especially difficult for smaller communities to absorb. We would strongly encourage the committee to make use of general fund resources for any direct appropriations in this bill or in the amendments that you consider today, rather than taking funds away from laid-off workers. I want to make a separate but related comment about some of the specific direct appropriations in this bill. As we've shared in the past, DEED would prefer to see workforce development funding provided via competitive grant processes that ensure accountability, fairness, and transparency. That said, we are especially opposed to any direct appropriations from the Workforce Development Fund that don't conform to its statutory purpose for employment and training programs. We would ask the committee to consider using general fund appropriations for the $1.5 million in Workforce Development Fund spending in this bill for business development organizations. I'd also like to mention we're disappointed to see that this bill eliminates state funding for the Minnesota Film and Television Board and their snow bait program. These resources, while overall a small investment, are critical to this industry in our state and result in both job creation and international publicity. In addition, we believe that the $5 million directed to DEED's housing program would be better directed to the MHFA Challenge program. This past year, DEED went through our first round of our market rate workforce housing program, and we do have $300,000 remaining from that round that will be carried over into next year. Well, you'll hear from Commissioner Tingerthal, the Challenge program has a significant need for resources. So we would suggest that would be a good use of funding. So those conclude my comments today. Again, I want to thank all of you for your work on this bill. While I've shared a few of DEED's concerns, we're hopeful that many of these issues can be resolved over the next month or so before legislative session ends. And if I can just make a quick personal comment, as I will be transitioning, I just want to thank you all for working together over these past few years. It's truly been an honor, and just thank you for your partnership. Thank you, Mr. Chair.
I know I speak for the entire committee when we say good luck to you, Commissioner. Hopefully we still see you around here, and best wishes to you in the future. One question before we go to member questions. Is it the position of DEED that all the Minnesota Investment Fund and Job Creation Fund recipients, that none of those jobs would have been created absent government action?
Mr. Chair, members, those funds are in very high demand, and we do believe that they are making a critical difference. Our Job Creation Fund is fully spent for this fiscal year, and we only have a few remaining resources available in the Minnesota Investment Fund. But we do not believe that business expansion such as Shutterfly that was mentioned earlier would have happened here in Minnesota without those resources.
With the Minnesota Investment Fund, there's only been a couple of awards in Minneapolis and St. Paul, yet that's some of the places that have the highest unemployment rates. In addition, it's where we put the most amount of money for our transit infrastructure, billions of dollars. Why are we incentivizing development in the fringes where there's no transit in Shakopee out on 169 where Shutterfly is? Why are we incentivizing that versus incentivizing development in places with higher rates of unemployment and where we have huge amounts of public investment?
Mr. Chair, members, we are always working to direct economic development opportunities to communities that have available land, have available infrastructure, have available workers. That includes underserved communities in this state. And we are always working to showcase those communities as good locations for economic development projects. We have had a balance of economic development projects in the metro region as well as greater Minnesota. With the Job Creation Fund resources, we've seen that was our first program that serves statewide. And so we've been pleasantly pleased to see that we have had a good balance between metro and greater Minnesota projects.
Thank you, Commissioner.
Yep.
Representative Mahoney, Johnson, and then Clark. Representative Mahoney.
Well, thank you, Mr. Chair, and, if you were worried about transit and these jobs, I had a bill in that required that transit be a part of the criteria for any of these particular funds, but, and I'm still, apparently we don't have to hear the bill, so we could just slide it right on in any particular time. But I have a question for the Commissioner, and then I've got a couple others, just to kind of lay a base. Commissioner Sieben, Clark Sieben, what do you define as greater Minnesota?
Commissioner.
Is there a physical definition? Is there a number of counties, a map, or whatever?
Commissioner Clark Sieben.
Mr. Chair, members, I believe DEED would define it as any community outside of the 7-county metro area.
Okay, so thank you,
Representative
Mr.
Mahoney.
Chair. Commissioner, it's nice to hear on record something that I have heard a couple of times privately, that the majority of economic development goes to greater Minnesota rather than the urban areas of Minnesota. So I am happy with that. Do you have any idea as to those 6,000, 6,000 jobs that would likely go outside the 7-county metro area, or as some members might want to say, out into southwest or western Minnesota or northern Minnesota?
Commissioner
It's
Clark.
just a guess, I don't know, I'm not a lawyer, I don't have the answer already.
Commissioner.
Mr. Chair, members, I would say that based on what we've seen over this past few years with the Job Creation Fund and MIF, that it would be probably close to a 50-50 split of what occurs in the metro versus greater Minnesota. Historically, and this is over multiple decades, and not just our economic development programs, but other programs at DEED, about 80% of DEED's funding goes to communities in greater Minnesota.
And Representative Mahoney, it's worth a distinction noting here that the U.S. Census uses an 11-county metro area. So some of us in the committee do not consider Wright County, Sherburne County, Chisago County, and Isanti County to in fact be in greater Minnesota. We consider those as part of the metro area, and that's who the federal government does as well. And so if you use an 11-county metro statistic for these, the data that's being shared with us today, vastly different numbers. Vastly different numbers, but that's a conversation when we debate the bill. So,
No,
Representative Mahoney.
Mr. Chair, I've actually looked at those particular numbers too. I've been on this committee almost 20 years now, and I know you've only been on it a couple years, but you're a pretty smart guy, and I will give you, your staff is probably pretty good, and they put those numbers in front of you. But I also will tell you that I typically break into a sweat outside the 694, 494. It's just the way I was brought up. Commissioner Sieben, and having said that, I think Representative Gunther will say that I have never not bent over backwards to help greater Minnesota and the jobs. Not because I don't like urban Minnesota, it's just that I think they have a fair share that they need. But Commissioner Clark Sieben, how many companies are you talking to that are looking to come to Minnesota or to invest in their current companies in Minnesota? Do you have in that pipeline that these multiple millions of dollars of cuts to these two programs will affect? Is it 10 companies? Is it 110 companies?
Commissioner Clark Sieben.
Mr. Chair, members, currently we have about 45 companies that we are in serious talks with, either Minnesota companies that are looking to expand or companies from outside of our state that are looking to relocate.
Representative Mahoney.
And what will be the case if these cuts go into effect for those 45 companies?
Commissioner Clark Sieben.
Mr. Chair, members, so, we are, not to repeat what I've already said, but we are estimating that the impacts of these cuts would total up to more than $1.1 billion in lost leveraged private investment dollars and 6,000 jobs that would have been created if those resources were in place.
Representative Mahoney.
So she didn't have the answer to that, but I'm going to be kind because she's leaving. And so my question is, then I'll rephrase the question. And those companies, those 45 companies, that would typically be, if we're going to follow your previous answer of probably a 50-50 split, so 20 or 25 of those, 22 of those companies were situated in greater Minnesota. Is that correct?
Commissioner Clark Sieben.
Likely?
Mr. Chair, members, it's an estimate.
Okay.
But lately we've seen a 50-50 split.
Representative Mahoney.
Mr. Chair, I could go on. You're taking the money from the Job Creation Fund and the Minnesota Investment Fund and some housing funds, and you're putting 1,600 laid off, at risk 1,600 laid off workers. I laughingly spoke to a poisoned pill earlier. This has been a very well thought of. The governor really likes these two programs, and to take this money from job development, creating 6,000 jobs across the state, to fund your broadband initiative when you've got a $900 million budget surplus. So you're saying goodbye to the likelihood or the possibility of 6,000 jobs because you're unwilling to tap into the budget surplus. I just don't get it. This is a poison pill, Mr. Chair. This is a poison pill large enough to choke a horse. And I just don't understand why you and your members who ran on helping Greater Minnesota would do something like this to take 3,000 jobs, the tax base, the property taxes, the income tax base, the people that would live in these counties out of the equation for Greater Minnesota. You ran to help Greater Minnesota, and what you're doing with this bill and what the commissioner has just said is you're slamming and hurting Greater Minnesota. I don't know if you got an answer for that, Mr. Chair, but why don't you like Greater Minnesota?
Representative Mahoney, I am happy to debate the merits of the bill now, but I thought it would be better if we did that tonight so we can get as much public testimony into right now for people who've driven here and wish to testify and not wait until after the House recess.
That's fine. I'll repeat it in a couple hours.
Okay, so I'm happy to do that, but I do think it's important to point out that in the MIF fund, roughly 75% of the jobs created are outside of the 11 county metro area. And that's not my numbers, that's what comes from, or 75% is in the 11 county metro. Nice job of making the opposite point. 75% of the jobs created are in the 11 county metro area. And that's from the DEED website. That's what it says. So this criticism of lack of economic development for Greater Minnesota, I think that there are far more efficient and better ways than the current program. And those are DEED's own reporting requirements. But again, my preference would be we have this debate on the bill tonight, and that right now we just stick to questions for the commissioner, not questions for me, and that we get to as many testifiers before the committee recesses. All right? Representative Johnson, then Clark.
Thank you, Mr. Chair and Commissioner. Good to see you. Just to confirm, on the broadband grant program, the broadband grants are awarded in a technologically neutral fashion, isn't that correct? That what they look at is what is the best investment and what's the best public return on that investment? Is that how it works?
Commissioner Clark Stephen.
Mr. Chair, members, yes, we have specific scoring criteria.
And the reason I ask that, because I get a little concerned about, as this bill does micromanage how the broadband grant program should be awarding money. It's probably not the worst thing in the world, but $1 million to fixed or mobile wireless, that might make sense, but it seems to me we should be following the criteria and judgment of the folks that are studying this in the broadband development office rather than micromanaging how they should spend it. I think that'd be a more efficient and effective use of the money that we have. Does that make sense to you?
Commissioner Clark Stephen.
Mr. Chair, members, yes, that does make sense. Thank you for that comment. We did fund a wireless project this last round of funding, so that is a technology that is able to be funded through the existing program.
Representative John.
And thank you, Commissioner. Again, I don't have any problem with wireless, but I just think we should use the money where it's most effective and most likely to provide the biggest bang for the buck. Thank you.
Representative Clark.
Thank you, Mr. Chairman, and we are going to miss you. I just wanted to ask you, though, if you had lots of good details in your statement. Do you have it in writing? I didn't see a letter here for us. Could we have that? Thank you.
Any other questions from the committee? Thank you very much for your testimony. We're going to miss you. Thank you.
Thank you.
Commissioner Rothman, you're next, and then on deck is Commissioner Tingerthal. Welcome to the committee. Please state your name for the record.
Mr. Chair, Mike Rothman, Commissioner of Commerce. Thank you for this opportunity to provide the department's perspective on the omnibus budget bill as currently drafted. I first want to express concern and disappointment about two important proposals that are not included in the legislation that the department recommended. The bill does not include the department's request for flexible funding that would enable the agency's Energy Regulation and Planning Unit to stay on top of its increasing workload and protecting the state's business and residential ratepayers before the Public Utilities Commission. Instead, the bill provided $100,000, inadequate amount, and without the necessary flexibility that an assessment and special revenue fund will provide. I hope, Mr. Chair and members, that we'll be able to have continuing dialogue conversation about the department's proposal and hopefully succeed at getting that. Currently, the Energy Regulation and Planning Unit is working on major utility rate cases with close to $390 million that utilities are proposing in additional cost to Minnesota consumers and businesses, as well as certificate of need proceedings involving more than $3 billion in new energy infrastructure such as transmission lines and pipelines. The case is clear that the department needs additional resources to keep pace with these major projects. Second, the bill omits the joint proposal by the Commerce Department and the Petrofund Board to extend the Petrofund's sunset date from June 30, 2017 to June 30, 2022. It is important to take action now to renew the Petrofund program for an additional 5 years. Tank owners, environmental consultants, and insurance companies would need to pour a tremendous amount of resources into obtaining insurance coverage over the next year. That's why it's important to do it now and not delay a decision to extend the program, which would create uncertainty and cost burdens for these property owners and the Petrofund itself. Without the extension, just to reiterate, of the program, Minnesota's Petrofund tank owners would need to obtain private insurance or risk the financial hardship of paying by themselves the significant costs of investigating and cleaning up petroleum contamination. Therefore, it is important to take action now to renew the Petrofund program for an additional 5 years. So let me turn to address specific provisions that are included in the bill. I'll refer to the article and section numbers and then explain our issues with them. In Article 1, Section 7, Subdivision 2 on telecommunications, this would cut the department's funding for telecommunications in fiscal year 17 by $376,000, with a new base of $558,000 in FY18 and $482,000 in FY19. This severe reduction in funding would deal a crippling blow to the department's ability to advocate on behalf of Minnesota's consumers and businesses to protect the public interest on telecommunications issues at the Public Utilities Commission. In particular, the department would be unable to regulate basic telephone service that continues to be a communications and economic lifeline for the state's residents, businesses, and communities, especially for senior citizens and those in greater Minnesota. A budget cut of this magnitude would result in a loss of up to 2/3 of the telecommunications staff in our department, 4 out of 6 positions. In effect, it would silence critical advocacy necessary on behalf of Minnesotans, consumers, businesses, before the Public Utilities Commission. Next, Article 1, Section 7, Subdivision 3 on energy resources. Again, as I mentioned above, the bill should, but does not include commerce flexible funding. We appreciate the additional funding. However, it is inadequate and would not allow us the ability to keep pace with the growing amount of work that we have at the department. And again, I hope we can continue to discuss our proposal. Article 1, Section 7, Subdivision 4, and Section 11, Subdivision 8 on insurance proposes $125,000 in fiscal year 17 from the general fund for insurance fraud enforcement. A laudable goal, insurance fraud enforcement is a top priority for the Commerce Department, and we have achieved significant results in recent years. Last year, the governor's budget included additional support for our fraud enforcement efforts, and we welcome more resources for the program. However, this proposal cuts needed resources in the department's budget in one area and redistributes the money to fund one civil fraud enforcement position. The proposal as drafted does not actually add resources to the department in order to fight fraud. Article 1 on telephone regulation, Sections 1 through 3 on voice over Internet protocol. We strongly oppose this proposal, as you would expect, which would eliminate state regulation and consumer protections for voice over Internet protocol, VoIP, and Internet protocol-enabled services. In effect, the proposal would drive deregulation of Minnesota's telecommunications market and eliminate vital consumer protections. It would remove the department's longstanding ability to help Minnesota consumers and the businesses throughout Minnesota with complaints on billing, service termination, failure to obtain service, and fairness of rates.
Commissioner, I apologize for interrupting you. I just want to let you know that your written testimony we made copies of and gave to all members of the committee. So it seems like you're working pretty closely off this. So again, members of the committee have this. Is there anything that you wish to add that is not in your written testimony or add some context on? Because I know both parties are caucusing right now, and I'm just worried that members are going to see this and go, hey, I have this in my packet, and think. So you're free to testify the way you want, but we did make copies of your testimony available for everyone.
Mr. Chair, I appreciate that. I am going a little bit off of my written comments and highlighting some important points.
Please continue.
Article 13 on energy, Section 1 and 2 on Renewable Development Fund. Again, we oppose this proposal. It would cap and eventually end Xcel's obligation to fund the Renewable Development Fund. It would do so actually over a quicker period of time. For many years, as you know, this has served as a resource to expand our renewable energy market, and at a time when it's important for Minnesota to continue to develop it, we believe that it's turning back the clock and a step backwards. Section 7 through 8 on exempting energy consumed by pipelines. This would substantially undercut the SIP program. The total impact of these provisions could be substantial depending upon which utility, particularly because there seems to be no limitation on the types of pipelines, whether petroleum, natural gas, or other products that are included. Section 9 on municipal and co-op SIP, the SIP goal. Again, as I indicated there that we oppose this proposal. It would effectively eliminate, the department's discretion to make a decision to adjust the energy savings goals of a municipal utility or cooperative association. There is no lower limit. And as you know, SIP is an important program, I believe, and we should not weaken, a program that reflects the state's longstanding commitment to energy efficiency. Section 10, exempting interstate pipelines from certificates of need. The Department of Commerce opposes this proposal to exempt oil pipelines, including Sandpiper and Line 3, from a certificate of need at the Public Utilities Commission. It would effectively eliminate crucial public review of the need for pipeline projects, which are substantial public public interest issues in front of the Public Utilities Commission. And finally, Section 12, Mr. Chair, prohibits the expenditure of state funds on the Clean Power Plan. The Commerce Department strongly opposes this section. It would prohibit state agencies from spending funds on developing a state plan until the courts determine the legal authority of the EPA to require submission of state plans. The federal court's stay on the Clean Power Plant implementation is procedural. Minnesota is well positioned to meet the goals of the plan, and it is in the state's best interest to continue to be prepared in the likely event the EPA rule is upheld. Minnesota has made substantial progress. We are working in collaboration with the Minnesota Pollution Control Agency, and we would not want to see this provision in this bill. Mr. Chair, thank you for the opportunity to share our department's concerns. Again, I'm open to continuing dialogue and hope you will take these considerations as you move forward.
Thank you, Commissioner. Questions from members of the committee? Representative Scott, and then Representative Johnson.
Thank you, Mr. Chair. Commissioner Rothman, just had a question on the committee's budget in regard to the recent news of the Vandahay lawsuit, and just wondering how much your department is anticipating having to spend on that lawsuit.
Commissioner.
Mr. Chair, Representative, at this time, I don't know. I don't have a preliminary estimate.
Representative Scott.
Thank you, Mr. Chair. And so you haven't set aside any dollars for that lawsuit at this point in time?
Commissioner.
Mr. Chair, Representative, not at this time. No.
Okay. And then, Mr. Chair,
Representative Scott.
thank you. I just had a couple of questions since we have the commissioners here on the investigation regarding the Community Action Program of Minneapolis. I'm just wondering if you've been questioned or participated in any way in an investigation regarding that program.
Commissioner Rothman.
Mr. Chair and Representative, the matter was looked into by the legislative auditor. The Department of Commerce itself has an investigation over the Community Action Agency, and it is cooperating with other federal investigators. The department has fully cooperated, as have I, on any of these.
Representative Scott?
Thank you, Mr. Chair. But have you been questioned regarding the investigation?
Commissioner?
Mr. Chair and Representative Scott, I don't recall being specifically asked by any of the investigations. I know that my staff has extensively cooperated and provided all the information that has been asked of the department.
Mr. Chair, one last question. We appreciate that the staff's been cooperative. And so who has paid for the legal cost, if any has been incurred regarding this investigation?
Commissioner Rothman?
And how much might that have been?
Commissioner Rothman?
Mr. Chair, Representative Scott, when you refer to this investigation, the Department of Commerce has had an investigation open and pending for quite a long time. It's part of our investigative resources. I don't have a specific dollar figure, but I'm happy to try to figure something out.
All right, members, I have to recess the committee. I've just been informed of this. So I'm sorry. My wish is that we continue taking testimony, but I am being told to recess the committee to the call of the chair. My apologies to the commissioners and testifiers, but we're going to recess to the call of the chair. Please monitor the listserv, email, and social media for further updates on scheduling. With that, we are in recess to the call of the chair. Thank you.